Welcome members, it's the 34th meeting of the Committee for Justice and the meeting is now open to the public. Please be aware that the committee is going to be recorded and broadcast throughout Parliament buildings and online. It's proposed, as usual, that when we're having evidence, that the oral evidence sessions with the Northern Ireland Commissioner for Children and Young People and the Children's Law Centre on the Justice Bill are going to be recorded by Hansard. Are members agreed? Thank you. Members, just as usual, we're obliged to declare any financial or other relevant interests, thank you very much, Stephen, that might reasonably be thought by others to influence our approach to matters under consideration. Anybody who's got an interest to declare should do so now or at the particular item on the agenda. Does anybody have an interest they wish to declare at this stage? Could I declare that I have an immediate family member who works in the legal profession? Danny?
Immediate family member works in the probation board.
Thank you, and a number of us also are members of the APG on access to justice. Before we move into other issues, we now have some folks with us in the gallery, some who will be giving evidence in the course of the day, but could I just remind everybody in the gallery that you are allowed to use your mobile phone provided it's muted and in airplane mode, and also if you want to connect our Wi-Fi, details of the password are in the gallery there for you to do that. Also, it's prohibited to take photographs or record any of the meeting, although why anybody would ever want to do that escapes me, but there we are. Agenda item 1 is apologies. I have apologies from Deirdre, who's unwell, and Justin, who's got a diary clash. I presume there are no more apologies, and we have with us virtually Ciara Ferguson, Doug Beattie and Maurice Bradley. Agenda item 2 is draft minutes. Could I ask members to turn to pages 5 to 12 of your pack, where you'll find the minutes of Thursday the 20th of March, this last week's meeting. Are members content that that those minutes are a true and accurate reflection of the proceedings of that meeting on the 20th? Mm-hmm. Content? Yeah. That's fine, and I'll sign the minutes. Agenda item 3 is matters arising. We don't have any. Does anybody else? No? Thank you. So that takes us to agenda item 4, which is the evidence from the Northern Ireland Commissioner for Children and Young People, and I would ask members to turn to pages 14 to 70 of the packs. So if you guys would like to come forward, thank you. So members, we have Chris Quinn, who is the Commissioner for Children and Young People, Joanne McGurk, who's the Head of Legal and Investigations, and Rachel Woods, who is no stranger to any of us. Hello, Rachel. A Senior Policy and Research Officer, who are here to give us oral evidence. Folks, you're all very welcome. Thank you very much for taking the time. We appreciate it, and we're looking forward to what you have to say. We've all read your paper. My plan today is that you will kind of give us your opening statements. Yeah. Probably about 10 to 15 minutes, if that works for you. And then in terms of questions, so that we're kind of in an orderly fashion, my intent would be to take each part of the bill as it comes, if that's all right, and we'll work through that way. It's just, rather than jumping back and forward by person, I think it's better to cover it by subject. Sure. Is that all right?
No problem.
That's lovely. So on that basis, I will hand over to you. Thank you.
Thank you. So thank you, Chair, and thank you to the committee for inviting us to give evidence today. This is our first appearance in front of the Justice Committee, and I wish you all the best in your endeavours and hope that I am back in front of you again sometime soon. So I'll work on the assumption that the committee is aware of my role and remit, as well as the legislation that established my office, as well as the UNCRC General Comment 27 as outlined in our submission, our written submission. My evidence today is not intended to be across all clauses of the bill, which are extensive and complex, but to instead address the key issues, the key aspects of the legislation that most directly engage with children's rights. And then I wish to close by highlighting a few gaps which I would encourage the committee to consider. We're aware that there are further amendments, but given timescales, I am unable to comment on those now, but I'll be happy to return to the committee and provide evidence if you would find that useful. So in opening, I'd like to stress the importance on hearing directly from children on their rights on youth justice and ensuring their voice is heard, particularly on the issues that are raised here. It would be great to see a panel of young people in this room or online speaking directly to you on the provisions and giving you their opinions. I have had the pleasure of speaking with lots of children, young people, families and professionals that work with them across the sectors of the victims of crime, young people involved in restorative justice programmes, young people with lived experiences, and as well as young people in the JJC and their parents, which all of whom I'm sure would give you invaluable insights to this bill. So going to part 1 on biometrics and DNA retention. At the outset, we wish to acknowledge the effectiveness of DNA and fingerprint evidence in the detection and prosecution of crime, and we also recognise that it will be necessary to collect and retain DNA profiles and fingerprints for the purposes of criminal investigations, and that in some cases this may include retaining data relating to children. We are concerned, however, that the principles of proportionality, necessity and presumption of innocence, alongside the child's best interest principle, should strongly underpin the legislative provisions and therefore impose strict limits on data retention. We welcome the changes that have been made to proposed retention regimes, which were and are currently indefinite without review periods. We are unclear as to why the 75-50-25 model has been chosen and for the timeframes proposed with children. Some of our concerns have been outlined in the written submission, so I won't go into them in much detail here, but just to flag that particularly relating to retention on proportionality, the retention of data for those children undergoing restorative justice schemes or diversionary disposals, and the need for age-appropriate and accessible information and guidance on data retention and collection. I wish to draw the committee's attention to 63G, which deals with those arrested but not charged. As this relates to children, we hope the committee will ensure that children are not further stigmatised and that these provisions are proportionate and adhere to their rights. We have noted in our submission a number of other recommendations for the committee, including on the creation of a biometrics commissioner, suggesting some areas for that office and the office holder to have responsibility and roles over, including appeals and the importance of reviews. We would ask the committee to consider reviewing the retention of children's DNA data and fingerprints once they reach 18, including an application process so they might be given an opportunity to enter adulthood with a clean slate. This decision would of course be dependent on the seriousness of the crimes committed and the number of offences for which they have been convicted with appropriate safeguards. Part 2, entitled Children, and contains several provisions that I understand to have been intended for a previous Justice Bill, particularly those relating to bail and remand. I therefore welcome that the committee are scrutinising them now, however recognise that there has been a delay, which is disappointing. From the outset, it is important to note our long-held position that children should only be subjected to bail conditions where they are absolutely necessary, and disproportionate onerous conditions should be avoided as far as possible. Further, any bail decision should be subject to an appeal or review. There should be a strong statutory right for bail for children, subject to the power of police and court to refuse it in limited circumstances. I very much welcome the clauses in the bill that speak to put on the statute books that children are never imprisoned with adults. This is an important legislative step forward in the realisation of children's rights. Part 3 outlines proposals to extend the use of live links. I'm aware that there is a further amendment proposed in this, which I cannot cover today, but relating to which is in front of us, I wish to impress on the committee the importance of the best interests of the child and also of consent. Nikki recognises that the use of live links in the criminal justice system has and does yield benefits, particularly for victims of crime. We have supported and continue to do so remote evidence centres and had the pleasure of visiting the site in Belfast. The expansion of live links into other non-court facilities may improve the experience for children and vulnerable witnesses in general, with the appropriate safeguards and processes in place. However, Nikki has a number of questions and concerns over the potential of the expansion of the use of live links for children's rights and access to justice. Appearing in front of a judge can be an important safeguard for anyone who has been deprived of their liberty. We also encourage the committee to ensure that a condition relating to competency to fully understand proceedings is considered, as well as mandatory training on ACEs and trauma-informed practice and on children's rights be given to all those professionals dealing with children in these cases. And we encourage that the committee fully consider the voice of the child in terms of those providing consent, the ability of children to provide and understand what is it that they are consenting to during legal proceedings. The ability to consent to proceedings and processes must apply to those children who are victims and who are suspects within the system. The availability and accessibility of age-appropriate guidance is key here, as well as training for all those involved in the processes. We agree with the Northern Ireland Human Rights Commission, who suggested the use of live links should be monitored across the justice system so that it does not become the norm and is not used inappropriately. This is particularly important to their use with children. Part 4 relates to various areas of the administration of justice. I will not be providing comment on all of these areas, but draw attention to that which relates to criminal record certificates. We have provided support for the registered intermediary clauses and trust our written submission captures the reasoning why. On records, we appreciate that the changes have been made as a direct result of the Supreme Court case are already in practice, and that full public consultation on the matter may not have been appropriate. It is unclear as to the rationale for the second reason provided, which we have also outlined in our submission. Nikki is not aware of specific safeguarding risks to vulnerable groups that an application process on wiping slate clean would have, and would encourage for the committee to fully evaluate the impact of having an application process available for children who have reached 18 to avail of, including evidence that it has led to the department to this position. I want to take the opportunity to outline a number of important issues that are not in the bill, but we believe that do meet scope. It is of deep disappointment that despite this being a miscellaneous provisions bill, further provisions relating to children's justice has not been brought forward, particularly in relation to the minimum age of criminal responsibility and equal protection. The committee will be aware that the age of the child can be held criminally responsible in Northern Ireland is 10 years old, one of the lowest in Europe. This is entirely against international standards, against the scientific knowledge that we have and know, and undermines children's rights. The UN Committee on the Rights of the Child have continuously called for the UK and Northern Ireland to raise the age. A graduated approach, which was first outlined by the 2011 Youth Justice Review, is no longer appropriate. Raising the age of criminal responsibility will progress our journey to being rights compliant, where every child gets the best start in life. A suggested amendment for the committee has been provided in our submission. It is also of great disappointment that legislation on equal protection has not been yet realised, despite multiple attempts. Children do not have equal protection from assault. This is a fundamental breach of their rights. Again, in the regular examinations of how well the UK and devolved governments are meeting their obligations, the UN Committee on the Rights of the Child has repeatedly stated that the issue of physical punishment must be properly addressed. It must be explicitly prohibited in law. I request that the committee consider ensuring that equal protection under the law for children from all forms of assault, including physical punishment, is addressed within the bill. To a few other areas I wish to raise with the committee in the context of the bill: that the expanding of the abuse of trust provisions, minors out of court settlements, and the use of spit and bite cards on children. Some of the committee members will recall that during the Assembly scrutiny on the Sexual Offences and Trafficking Victims Act 2022, the abuse of trust provisions was expanded to include religion and sport, but not extracurricular activities. It was disappointing that further areas could not be legislated for then. The committee may wish to further explore how the extension of such abuse of trust protections could be secured within the bill's scope, particularly as it relates to children. Finally, the committee will be aware that following 2 years' use as a temporary measure in June 2022, the PSNI decided to continue the use of spit and bite cards as a permanent tactical option, including on children. This is despite a variety of recommendations from the Northern Ireland Policing Board's Human Rights Reviews, the Police Ombudsman, the UN Committee's concluding observations and recommendations made by children's rights organisations in the sector here. It's Nicky's continuing position that the presumption that spit and bite guards will not be used on children is too vague and leaves scope for routine use on children. Because this is an operational matter, the PSNI can continue to use them with appropriate safeguards in place, which Nicky does not consider to be tight enough. I believe that the only means by which spit and bite guards will not be used on children is to ban their use. I encourage the committee to consider this in the bill. You'll be glad that that's where I pause and give you an opportunity to ask us any questions you might have. So thank you.
Yes, thank you very much, and thank you for your evidence there. I suppose firstly, by way of reassurance, yes, it is absolutely our intention to hear directly from children and young people, and we plan a number of ways to engage with them. One of which, just off the top of my head, is through the youth assembly and so on. But we do intend to try and engage with children who have experience of the processes and so on too, to see how things can be made better for them. So that's our first point of reassurance. Right, let's look at the first point then in terms of biometrics. In part 1 of the bill. So on that I've got Danny and Doug for you, and other people obviously may jump in as the discussion continues, but we're going to start off with Danny and then Doug. Thank you.
Thank you, Chair, and thank you for the presentation. I suppose, Chris, I'm really concerned about the stigmatisation of children and young people when it comes to the retention of their data, and I just wanted to elaborate a wee bit more on your exact concerns that you have within this bill with retention in regards to children and young people.
Yeah, it's a big concern of ours as well, Danny. To give myself a chance to catch my breath, I'm going to pass to Rachel. If you want to come in on biometrics first, and I'll come in behind you.
Yeah, thank you, Danny. And I suppose it's just like a lot of things within this bill. We are talking about children and young people, some of the most vulnerable people in society, and those that do get stigmatised by us in general, and having your data retained for longer than is proportionate and necessary will only seek to further that. But we know from a lot of research out there that once a child is in the criminal justice system, it almost kind of sets them on a path, and that is despite the significant work that the Youth Justice Agency, the Youth Justice Services have done, in diversion. But we do have a situation here in Northern Ireland, as we know, that any child over 10 years old will have their DNA taken for life currently at the moment, and that's because of the minimum age of criminal responsibility. And we've raised throughout our briefing issues that we consider key to talk about stigma and talk about children and young people. How the police perceive children and young people as well, how the criminal justice system perceives children and young people. Once you've got your data, and that's not just your biometrics and your DNA, we also need to consider this kind of the softer data that is retained as well, the intelligence data. The term "the dogs in the street" know who it is, and it's usually the children and young people that have been in contact with police, that they know or they assume to know, and they're troublemakers in their communities, and they're the first ones kind of picked up. We've heard directly from children and young people lived experience of this, and they were in the wrong place at the wrong time. It wasn't us, but they meet the description, or the police might know who they are, and they are targeted on this. So having retention periods of data and DNA would only further that, and it does feed into kind of once you've been in contact with the criminal justice system, you're basically on a path to continue. And it's not compliant with children and people's rights, and it's certainly not in their best interests to have their data retained for that length of time. It also will imply a criminal record, and we can get onto that later on within part 4, but all of those things feed into the stigmatisation of children and young people, particularly those who are in contact with the criminal justice system more so than others. We do have our overrepresentation of care experienced children and young people in the system, those with their own difficulties in SEND, and we can go into that if you want to. But there are specific groups of children and young people that it does really affect.
And what approach would you like to see in this justice bill from the minister or from this committee and our scrutinising of it to make that better?
Well, I suppose in terms of, if we go with the child's best interest being the overarching principle, we really need to look at proportionality and need. So it was interesting to hear from the Scottish Biometrics Commissioner, where the committee received evidence from him a couple of weeks ago. about the usefulness of biometrics and data and facial recognition technology within the solving of crime. So kind of have to strip this back as well to why we retain DNA and data and for what purpose. If it's for crime prevention, that's not showing from his perspective. I believe it was 0.34% of all recorded crime was solved with biometrics and 2% with facial recognition technology. That is not, therefore, it's not the overarching reason why crime is solved. So we need to go with the principles of proportionality and reasonableness and within the child's best interests. We've drawn particular attention in our briefing about the diversionary disposals, cautions and community restorative justice. Those are supposed to be diversionary disposals, and the key here is the word diversionary. They're supposed to be diverting children and young people from the criminal justice system, not entrenching them further in it. And if we are saying that it is proportionate to retain data of children and young people for 5 years after the completion of a diversionary disposal, how diversionary is that? We've also drawn attention to the fact that there could be a difference in DNA retention if it was a court-ordered community restorative justice disposal, or if it was one referred to by the police that didn't actually go to court. Also, cautions are not convictions, neither are restorative justice schemes or diversionary disposals. So we sort of urge the committee to have a look at that, and if that is reasonable, proportional and lawful in line with children's rights.
I'm not saying. Thank you, Chair. Thank you.
Okay, Danny, thank you. Doug?
Chair, thank you. And Chris, thank you for your evidence and the substantial paper that you've written. And I can see the hand of Rachel on that paper already and listening even to her answering this. But I want to sort of push on what Danny has said about this negative effect on children if their biometrics is retained. I'm just not quite getting it. And I'm genuine when I'm saying this, and I'm not just challenging for the sake of challenging, but I'm being genuine when I say, are we really saying that a 16-year-old who have their fingerprints taken, and that's going to have a negative effect in their childhood or in later life? I know for a fact when I was younger, I had my fingerprints taken, and once it's done, it's done. I never reflect back on it. I don't think about it. And how many children have come to you and said they've got my fingerprints or they've taken a mouth swab of me and it makes me feel stigmatized? Is this really an issue for the children? Or is this really an issue for us who are looking at this from a different perspective?
Thank you, Doug. I suppose when I think about this, my default goes back to, well, is it proportionate? Is it necessary? And is it appropriate? And we do, I suppose what we're trying to do is look towards a system that gives young people opportunities, a system of rehabilitation, avoids that stigmatisation. And I think, as Rachel says, the Scottish Biometrics Commissioner's evidence recently was quite stark, I felt, in terms of the percentages of crimes that were solved and the issues that he raised around the facial recognition. So I think those statistics, I feel, back up the position that we're putting forward. I suppose the McGurk conversation as well is really relevant in this conversation, that we do have a very, very low age of criminal responsibility, and we have said in our submission that ought to be raised. But yeah, I suppose it's about giving children and young people the best opportunities in their life. And my position would be that retaining that data isn't proportionate or necessary or in the child's best interests. I don't know if colleagues want to.
I guess I kind of get that, Chris, and I'm not necessarily disagreeing with you. So I'm kind of trying to tease this out, maybe just in challenging. And I think Rachel said something that there's not a great deal of prevention that goes about with retaining this DNA material, but it does help in later life with protections. And I'm really sort of into this business of that crossover between young person and child to young adult. At 17 and a half, they'd fall under what you're talking about, where it stigmatizes them at 17 and a half, but does it stigmatize them when they're 18? So I'm just really trying to get an understanding. Does it really stigmatise them, or is this just us doing something because it's the right thing to do, because we think it's the right thing to do in society, but actually it doesn't have that much an effect on the child?
Yeah, I mean, I would argue that it does stigmatise the child regardless of age. And I suppose when we think about how the child feels about themselves in that process, you know, what is the purpose? What does the child understand about that data being taken? What will happen with that data? You know, what's the impact on other elements of their lives, and you know, how they'll view their own life chances. I do speak to a lot of children with self-limiting belief, and this is part of that. You know, I'm not saying it's the be-all and end-all, but we do need to create environments where children can flourish. And indeed the UNCRC, which we're arguing should be incorporated into domestic law, does give children certain protections around their safety and their privacy. And I suppose that privacy piece speaks directly to the UNCRC.
Good enough.
Yeah.
Sorry.
I think there probably is just a quick point around privacy and the balancing act that needs to take place, and I think Chris has talked about necessary and proportionate. I think that's part of it as well, that needs to be taken into consideration. And when you look at this, whether or not it's really necessary and proportionate, when you look at what's been reported by the Scottish Biometrics Commissioner about retention of the information.
But I guess but I guess that's my point, is that for the vast majority, you know, I was a child as well. For the vast majority of children, it happens and it's gone. But something then may happen in later life where actually that retention of the biometric material from when they were younger might help with even on a positive way with detection levels. But look, I think you've answered it very well. It's just I wanted to try and tease that out, and I think you've given me a good answer. Thank you, Chair.
Okay, Doug, thank you. Ciara?
Just on the same issue, I'd just love to kind of hear just your opinions clearly on both the under 18s convicted of a first minor offence and given a non-custodial sentence with the 5-year retention. So what do you want to see? And then likewise, for under 18s convicted of a first minor offence and given a custodial sentence of less than 5 years will result in a retention of 5 years plus the length of the sentence. So on those two for under 18s, what would you propose should be within the bill?
Okay. Rachel, do you want to?
Yeah. Sorry, Ciara, would you mind repeating just the specific? Do you know what the specific clauses are?
I don't. But it's specifically, you have spoken earlier on the under 18 just convicted of a first minor offence and given a non-custodial sentence.
Yeah.
Okay, which is 5-year retention, and then under 18s who have a first minor offence and are given a custodial sentence of less than 5 years, it will be 5 years plus the length of the sentence. So it's just kind of your thoughts on that, on both of those.
Okay, so I suppose we wouldn't have a specific year. It is trying to make sure that that is reasonable and that it is proportionate and it's within the rights. So I suppose it goes back to what's it being retained for. Specifically on a non-custodial sentence, so those are the more diversionary ones. Again, the key here for us is the word diversionary. And if you're given a community sentence, you're given a YDO, you're given a CRJ, CRN, what is the purpose of holding for 5 years, and is that in proportionate? Why is 5 years? And it brings us back to the question of why the 75-50-25 model as well. We are very unclear about where that model has come from. We have a number of different models operating across the UK and Ireland and indeed in Europe, all meeting the Cochrane judgment then as well. And it's about different systems and review mechanisms and appeal, you know, all of these other safeguards that are in place. So I suppose we would question about why 5 years. Is there any benefit to it? What are the negatives and the positives of that? We would obviously be looking for it to be less. And also we have proposed that the committee consider in effect a wipe slate clean at 18 then as well. Is there any reason for this biometric data and DNA to be continuously held? Is it with lawful purposes and is it within the child's best interests? Because if not, then what is the purpose of holding it? So I suppose if you're looking for a specific year, I would need to go back and do a lot more research on that one. But I suppose it's up to the committee to satisfy itself of whether or not they believe 5 years for diversionary or for non-custodial. For a first minor offence, again, we're looking at the child's best interest within the justice system. We're looking at custody as a last resort. So it is again to satisfy yourselves of whether or not retaining a data from, for the sentence plus 5 years, what does that achieve and what is it for? Again, we would consider something less, but if it was, 2 years, 3 years, I would need to come back to you. But again, it's just part of that discussion about why that model has been chosen and for what purpose. And we're still quite unclear about why that is.
In honesty, so are we. And we had sought, and as are a number of organisations who've given evidence, I think everybody's quite keen to understand the rationale behind the exact numbers chosen. Mm-hmm. And we sought it. There's information in our packs today, but I'm not sure it hits it for us. I'm not sure it fully explains. But so those are issues that we intend to follow up. Danny, you want? Let me just check. Ciara, are you finished? Do you want to come back in?
Yeah, no, thank you, Rachel.
Go ahead, Danny.
Oh, thank you, Chair. And I'm just sort of coming on the back of what Doug was sort of saying. It's just, for me, and I don't know if you'd share that view, it's the dangers of labelling our young people. And that's my fear in this. And I just wondered, would you share that as the Children's Commissioner, that's sort of where we're going with this here for the retention of their data?
Yeah, absolutely. And not to go into too much depth about people's personal stories. We do deal with lots of children who have been involved in the justice system or around the justice system, and a lot of the cases that we come across, we can see where children have been failed, where if a different approach might have been taken or a different opportunity had have arisen, they may not have ended up in the situation that they found themselves in. So it's that cycle, Danny. It's about ensuring that children don't find themselves in that cycle, and the evidence would suggest that once you're in the cycle continues. But stigmatisation, absolutely. I think that young people have enough. Generally, young people are negatively stereotyped and stigmatised, and I think this brings an extra layer. So we would be very concerned about that.
Yeah. Thank you, Chair.
Thanks, Danny. I think some of this will end up following on when we get to the next section on children's bail and custody. I'm fairly sure we'll touch on these issues again. Does anybody else have anything, or will I go ahead? Has anybody got anything? No, everybody's all right for now. Folks, there's a couple of things that I just want to understand or increase my knowledge around. In page 20 of your paper, sorry, it's our page 20, it's not page 20 of your paper. It's still in the biometric section, page 2, and it's B1, that children are not prosecuted as adult offenders without exception. Can I ask the extent to which that happens and the type of offences where that happens?
Gosh, I'm going to have to ask for some help on that one. Joanne, would you, from a legal perspective,
Although not a criminal practitioner, so I would have to certainly go away and look at that. There is obviously provision in this bill around the orders that are there, and there's exemptions made for certain behaviours. But in terms of the data, I think we'd need to go away and certainly can write into the committee with that if that's the case.
I think it would be helpful for us to have some understanding as to the extent of the issue there, because if you deemed it important enough to include in your paper, I think I would want to have a grasp as to the extent of it. Then if I could ask you to turn to page 4. So it's our page 22. Your page 4, and it's the second paragraph, where you indicate that you understand that there are going to be further amendments and the department intends to add custody images. I'm interested to know, I suppose, where you got that, because our correspondence with the department indicates not so, that they don't intend to legislate on this. Now, it's certainly an issue that we're looking into as to, okay, a custody image is one thing, but the point at which it's processed and uploaded and used for facial recognition purposes and that kind of thing, at that stage then it's biometric data. So we are looking at this, but I'm wondering kind of where you got that information from the department, because it's contrary to the information that we hold.
Sure, if that would be our understanding as well, apologies if it's come across in a slightly different way. It's just that there would be an amendment coming down, one of the 6 planned amendments from the department, to include the systems around photographs. So
No, we're being told the opposite of that, and what's being used at the minute. I mean, I think there's stuff in our packs that indicates they're not intending to move on that.
Okay, apologies, Chair, if I
that's
picked
okay.
that up wrong. That is entirely my mistake there on that one. But we would hope that it would include custody
we're looking
photographs.
at it to see, well, you know, what the issues are around this, and certainly, I mean, we're aware that the police currently are using, and there's a service instruction, and we've asked. The police are obviously going to come in and give evidence to us. We've asked to see their service instruction to kind of understand, okay, well is that sufficient? Let's see, you know, and obviously we're conscious of the various databases that there are and how all of those work and how the PSNI will feed into that. So keep an eye on that.
We'd certainly, we would consider photographs as biometrics for the purposes of this bill, and would definitely support that being included in a bill. We've also, there's been a number of discussions recently about the use of live facial recognition technology. I believe there was a report to the House of Commons relatively recently on police use of it. So our understanding that PSNI here don't currently use it, but could potentially come in. So we would be asking the committee to future-proof this legislation to ensure that this is covered. But for all intents and purposes, we would consider photographs as biometrics, despite their use obviously over time. A photograph of somebody 1 year and 30 years later might not be exactly the same, but they would hopefully under this bill. But
you're using them as biometrics at the point at which we talk about whenever they're processed and uploaded and used, as opposed to just the. Okay, that's helpful. Thank you. Could I ask you then, page 6 of your paper, which is kind of the penultimate paragraph there that starts thirdly, and in that paragraph you refer to unintended consequences. Do you see where I am? Mm-hmm. Could you maybe give us an indication as to what you perceive those may be?
So this is in the context of potential changes that may come down the line as outlined in other consultations, and I point specifically to the measures to deal with antisocial behaviour. There were proposals within that joint consultation. I believe it was the Department of Communities and Department of Justice joint consultation earlier on late last year.
That's on our papers today. It's
excellent.
Like you're
And there were a number of queries that we put in. I'm more than happy to send over the committee our response to it, but it is available online about there were a particular order that applied to 16 and 17-year-olds, not just over 18s, because at the moment those fixed penalties only apply to 18 and over. So if there were any changes pending other legislative change on that in particular issue on antisocial behaviour, would this then necessitate biometrics and data being taken from 16 and 17-year-olds on new orders? I suppose it's trying to future-proof. And whilst I appreciate the committee are dealing with the legislation at hand and cannot look to future legislation that may not exist, absolutely appreciate that. It's about potentially just looking at the changes that may come down the line, particularly this mandate and very soon, that we are also considering at a time, and trying to get that balance right with the likes of fixed penalties, which are not criminal convictions at all. They're civil, and about the impact that this legislating as currently in this bill in Part 1 on biometrics may have down the line.
No. That's fair enough, thank you. And certainly, I mean, the fixed penalty stuff we were looking at too and thinking, I'm not clear at this juncture what possibly you could get a fixed penalty for that would require you to submit DNA.
Exactly.
I couldn't think of a solitary thing, so we've asked some questions around that too to try and understand, okay, what's the issue there? Yes, lastly from me, I think, and this is page 26, so you're page 8. The issue about compliance notices from the Biometrics Commissioner. Can I maybe ask you to elaborate on your thoughts on that? You're not clear whether So the Scottish Biometrics Commissioner has power to issue compliance notices, but the proposal in front of us does not have that power. Do you want to give us, just elaborate a bit more on what you think about that?
Yes, please. Thank you, Rachel.
I suppose even just from a perspective looking at the Scottish Biometrics Commissioner Act, much larger, much more detailed than what we have here. I appreciate that a lot of these may come through secondary regulations, and also that just may be a different style of legislating. And that was a specific act, whereas this is a miscellaneous bill. But we would hope that the Biometrics Commissioner would have all powers available and that which they need, because this is very significant change, and this is dealing with people's data and DNA. They're private data at the end of the day, and without significant review mechanisms within the Part 1 that we're dealing with at the moment as drafted, we would be looking to ensure that there is somewhere that someone could make a complaint to if their data wasn't being dealt with properly under the law. So the Scottish Biometrics Commissioner, as far as I understand, has those compliance powers. They also have additional powers that are not within our legislation as drafted. So we would be hoping that the committee could consider that to make that office as best as it could be. And also we've recommended that the Biometrics Commissioner have specific powers in relation to looking at vulnerable groups such as children and young people, so that there is a specific focus, just as there is in Scotland, on children and young people and their data.
Okay, thanks very much, Rachel. Thank you, folks. Does anybody have anything further on biometrics? If anything occurs as we move through, because it's not as if all of these issues are separate and distinct. I mean, they do overlap at times, so we can accommodate that if necessary. Okay, we're happy to move on then to part 2, which is children's bail and custody. So on that one, I have Doug coming in.
Yes, thank you, Chair. And Chris, can I just ask on this? And I'm asking the question for more information, but I'm actually supportive of this. So bail, remand and custody of children being a measure of last resort, support that, I understand that fully. But how do we balance that with the rights of the victim?
Okay. Well, I suppose, again, our evidence here is grounded in the best interests principles and in terms of proportionality and necessity and appropriateness. But in terms of the victim, I think you're absolutely right. There is a balancing act in all of this to be considered. Again, a lot of this goes back to the minimum age of criminal responsibility, some of what was discussed in Ray Jones's report on the review of children's social care. But I do think we need to look again at where we house, where children and young people are housed in terms of secure care and JJC. I think that's all part of it. I am going to ask Joanne to come in terms of bail, given that this is your area.
Oh, absolutely. And I'll refer to the formal investigation that we've referred to in our pack as well, which is an investigation that our office conducted into the life of a child in the care of the state. And what was found in that was that detention, and in some cases because she couldn't perfect her bail, but detention and onerous bail conditions created trauma, created reoffending. And I suppose the intention, and when we're looking at the victim, the intention with youth justice is to rehabilitate and ensure that there's not reoffending, and the victim is of course extremely important in terms of consideration as well. But it is that part of the youth justice process is to ensure that there's not reoffending, which is part of the I suppose outcome for all of society to prevent further offences.
And I guess in many ways we have to be honest in regards to this, because if we have a child or a young person who is continually reoffending, whether it's social behaviour or antisocial behaviour or something slightly more serious than that, then the victims are going to have to try and understand one way or the other, according to what you're trying to achieve here, is that child may not end up in bail or remand or in custody, even though they're repeat offenders. And that's going to be difficult, I think, for victims to understand that, if we really do also want to focus on on victims, particularly if that person is on the upper end of being a child, sort of at that 17 and a half years of age?
And I suppose in response, I'd say that it's not about there not being a consequence, or you're not being responsible for your actions, and there not being accountability. I think all of those things are important, but it's how we deal with them and how we ensure that, with looking at child rights lens in the best interest of the child, that there's an outcome for that young person that's not going to create further reoffending back into the justice system, and it's not going to balance their best interests as well as those of the victim.
No, absolutely. And I mean, you are advocates for the child, and I'm trying to look at this in the sort of the wider context. Even the mental health of a victim who sees the perpetrator, who just happens to be under the age of 18, continually roaming the streets, even though they've done pretty awful things in that area. And that's where I look at this and try and get a better understanding, so that people understand what we're trying to achieve in the wider sense here, and not just in a sort of a narrower sense.
Yeah, I guess, Doug, as well, there's this is a very complex bill, and there are various layers to it. When you're speaking there, I'm also thinking about the review. With a review not so long ago with regards to the JJC and the Secure Care Lakewood, but also the severity of different offences, and that thing about proportionality. So on the one hand, you're absolutely right. There are going to be situations where one form of action isn't as appropriate as another. But what I would say is that with a little bit of creativity, we have a marvellous facility at the JJC right now. But unfortunately, there's lots of space in there. It's not. It's a great thing that there's not too many people there. So I think we need to look carefully at the Ray Jones report as part of the solution to this, because, as I say, this is very complex, and often from a perspective of the needs of the child, that therapeutic trauma-informed approach, and the various different types of offences someone might commit.
Yeah, I think, Chris, you're absolutely right. I mean, this is extremely complex, and that's why we're looking at it, because I do, and not just on this particular issue, but on wider issues, I am concerned sometimes that the victim is sometimes forgotten in trying to do the right thing. We end up sort of traumatizing other people as well, and that's a difficult line to tread. But listen, thank you very much. Thank you, Chair.
Thank you, Doug. Danny?
Yeah, thank you, Chair. And thank you. How compliant do you believe the provisions on bail and remand and custody are with the UN or CRC?
Okay, Joanne, I'm going to pass to you again.
So in relation to Part 2, we've generally welcomed Part 2, but we have drawn out concerns in relation to Clause 5 and 6 of the bill. In particular, the wording around serious threat to public order, and I know that's come up beforehand. I think it's particularly relevant because then it impacts upon any conditions then that flow from that. And going back to the formal investigation that I've already mentioned, I'd like use it as a guiding principle in terms of where certainly in that case, the difficulty was that the bail conditions were so onerous. Like they were conditions that were really to manage a child rather than related to the reason that bail conditions should be granted.
The case study that is in your... Yeah.
It is, yeah. And it resulted in multiple ongoing arrests, and it certainly wasn't compliant with the UNCRC or children's rights compliance. When we look at these clauses and the wording, I think there's a real likelihood that they could be interpreted in a way that they aren't compliant, because the wording around causing serious threat to public order, particularly in Clause 6 and in Clause 5, does not appear to be solely down to the reason that, the right to bail. There's other influences, there's other factors, external factors that may be out of control.
Potentially. It's
yes,
brew.
Exactly.
And either you're entitled to bail or you're not. So
yeah.
I'm a bit concerned about this myself.
Yeah. Yeah.
What would you like to see within it then?
I think, although I think maybe further safeguards, it would need further clarity, and I think some expression as to, a stronger intention towards bail without conditions. That's clear, and that it's based on the best interest of the child. So I think we've asked for the best interest of the child to be reiterated in this piece of legislation, and I think that would be also helpful. And then certainly training, guidance, and looking into custody officers as well as the judiciary that would be imposing bail conditions, and the importance of those being based on the needs of the individual child.
And have you had any discussions with the Minister or her officials around the possibility of Clause 8 not being commenced? No?
Not recently, no.
No.
But I think we made it quite clear in our submission that we would not support the non-commencement of that clause. Like Joanne, you'd probably go into a wee bit more why, but I suppose just on the back of the clauses 5 and 6, which are of particular concern on the threat to public order, we would encourage the committee to consider that in and around the child criminal exploitation. And the potential actions of others, and who is at serious risk. Is it the child? Is it the community? And how that is interpreted. We consider that the EFM isn't overly clear on what the intention is of the department, and I know that has come up in committee before. But in considering the impacts of child criminal exploitation and the potential for a child or young person to be coerced into actions by others, that this would really need looked at, and how a court could interpret it. Again, I'm sure you would be engaging on that, but how that specific clause can be interpreted, and looking at it from the perspective of a child who has been coerced.
Okay, Danny.
Thank you, yeah.
Ciara?
Just a quick one, and just in relation to Clause 8, obviously we don't want to see young people remanded in custody unnecessarily. Have you had any thought on what is the current position in regard to accommodation? What is the level of maybe due to unavailability of appropriate bail accommodation young people are remanded in custody at this moment in time? I'd just like to get a feel for the current environment that we're operating in, and then from that as well, what kind of would you like to see? What is the scale and level that is required, say, post legislation that needs to take place, and I am conscious it's a Health and Social Care Trust that probably has a lot to do with this as well regarding providing appropriate accommodation, but just what's the environment at this moment in time in which the legal system is operating?
Yeah, I'm thinking of the formal investigation again.
Yeah. So certainly in terms of recent casework, we are seeing continuing cases where children and young people aren't able to perfect bail or aren't able to find suitable accommodation, and so JJC is the best worst option, so it certainly is an ongoing issue. As Chris has talked about the formal investigation, that was very much the case in the case of this young person that's called Vicky in this report, who spent over 450 days in the JJC, where she should have been on bail or on remand, or should have been in suitable accommodation. And the outcome, was very difficult. There was trauma experienced as a result. In terms of what we would like to see, we appreciate the practicalities, but it's simply not good enough. The formal investigation in that circumstance was in 2017 when that was occurring. We're now in 2025 and we're getting casework happening again. It's a continuing issue, and it happened before 2017. There's a clear responsibility on the trusts to be able to provide suitable accommodation to allow children and young people to perfect bail, and where custody and the retention of their liberty is not appropriate and has been determined by the court or the police as not appropriate. We know that there's been a bail fostering pilot. We know not a huge amount of detail on that. We understand it's been used, but we would like further information. We think it would be worth exploring how that can be rolled out through other trusts.
It was very limited use. I think there's only maybe 2 children.
Yeah.
So they've extended it from recollection, I think they've extended it to afford them an opportunity to gather a bit more data. But I think it was only even in one trust area, wasn't it?
One trust area, 2 children.
Yeah.
And I think there should be like short, medium and long-term planning in relation to this issue. You know, it's simply unacceptable that we are saying that custody for children who should not have, you know, the courts or police are determining that they should be on bail. That custody is the place that we place them. That's the best that we can do. These are vulnerable, often vulnerable young people, and it's not the appropriate accommodation for them. And Chris has talked about a little bit about regional youth and justice campus, and that may be a way to move it forward in the long term, but there's certainly an onus on the trust to move quickly on this issue in the short term. And also there's a Children's Services Cooperation Act that requires all departments to cooperate for the wellbeing of children, so there is an onus across all departments because it is an issue that touches many of the departments. Is there anything else?
Thank
want
you.
to add?
No, that's great. Thanks.
Okay, here. Anybody else got anything?
Not on this section,
Oh,
just later on, yeah.
No, I've got it just, I mean, just in this section.
Yeah, apologies.
Yeah, this is the trouble with this. I'm somewhere where Doug is, to be honest. So I don't want to see children stigmatised. I want them to have the best opportunities that there can be. And I appreciate that some children have a really bad start and it's difficult to overcome that. But I think they should be given the chances. But the other side of it is there are people who just behave badly, and we need to find a way and a balance to prevent them from doing that and prevent them from causing harm to other people. And I think we do need to consider the victims. And I'm wrestling with some of these areas myself and trying to think it through about what the repercussions are. So I'm still working my way through this. So bear with me. But the conditions thing concerns me. Complete, no conditions, free for all, worries me. I don't believe there should be onerous conditions, and certainly the case study that you present is horrifying. However, we do know from practitioners that actually sometimes conditions are helpful, and they're helpful for parents. Now, I'm not suggesting that bail conditions should be a means of good parenting, but what I'm saying is sometimes it's not bad parenting that results in a child ending up in the system. And so sometimes those parents need a bit of help to try and, I suppose, impose on their child the gravity of the situation that they're in. So back to all your business about fully understanding and all of those things. But again, for me, it's the balance. The safe space issue is key, and the suitable accommodation issue. I mean, my understanding was they were supposed to build somewhere, and that has been stopped because of budgetary pressures. But certainly custody is not ideal. But I don't think that any kind of custody, whether it's for an adult or child, custody is not the place to keep somebody safe. It shouldn't be happening regardless. It's not suitable accommodation. A police cell or jail cell is not suitable accommodation in those circumstances. So I think there needs to be work done, but I appreciate it's more vexatious for children. You mentioned the children and adults in prison together, and I presume that this refers to Hyde Bank, and you make reference to Hyde Bank. Again, could you give me some understanding of the numbers of what you would be perceived to be children stroke juveniles in Hyde Bank? Do you have any data around that?
Could I make a quick comment
Please
on
do.
your previous
Yes, of course, Chris.
points? Because I think what you're alluding to is the fundamentals. I'm not a lawyer. I'm not a drafter of bills, but I am an expert, and we are experts in children's rights and their best interests. In my opinion, all of these issues that we're talking about today are mixed together. So. For me, let's raise the age of criminal responsibility as a starting point. Let's look at the JJC and Lakewood as they stand. So there are facilities there. I don't think they're being used in the best way that they could. We've seen the success of restorative justice practice. We've seen how that can work for victims and for perpetrators. We need to invest more in that kind of the prevention element of all of this. We need to focus on educating children and young people. We need to focus, and I know I'm going way left field here on you, but we need to think about relationships and sexuality, education. We need to think about all of this as part of the one. We need to think about how our education system equips children and young people for life, and the dangers both online and offline. So I think with a little bit of creativity, we can make things work. I mean, Ray Jones, again, I'll go back to that in his report. He gives us lots of solutions, and they seem to have stuck. But I do think a fundamental starting point is raising the age of criminal responsibility and wrapping services around those people who are vulnerable to prevent these things. But taking on board your point of the victim, there will be very serious crimes that at times will be committed, but that's not the norm. Those instances are usually quite rare, thankfully. Your second question, sorry,
the rest was more kind of a stream of consciousness as I try to work through the issues, but my actual question was about the numbers of children and juveniles that are in Hidebank.
Yeah, I think that doesn't happen
anymore as practice. We believe these clauses are to put on statute, a practice that has been placed for around a decade. So we are welcoming those clauses that are being legislated for now. But we believe it's about 10 years since there has been. Yeah,
so
we wouldn't have any data on that. I don't believe it happens.
No, that's great. Does anybody else want to come in on these specific issues in terms of the age of criminal responsibility and the other issues around equal protection? We're going to come on to those. Yeah. It was in the final section when we kind of do a cover-all in terms of general questions. Yeah. So I think we'll have further conversations around that. Anybody else got anything on children's bail and custody? No? Can I move then to live links? Has anything arisen in terms of live links? We've noted your points about live links. I mean, and we understand kind of where that's coming from. So I don't think that's... Live links at this stage isn't massively controversial for us. Okay, part 4 then, administration of justice. Doug, I'm going to come on to you first.
Thank you, Chair. And Chris, again, I'm looking at the bit about disclosure, which is our page 47, and you talk about a clean slate at the age of 18. Mm-hmm. I'm going to be honest with you, I wouldn't be supportive of that. I think it's more should be based around crime rather than age. Could you give us your rationale for the clean slate at the age of 18?
Yeah, it's a really valid question, Doug, and something we have give lots of consideration to. I know Rachel will want to come in on this, but we have talked already about the stigmatisation and criminal age of responsibility, and the seriousness, the degrees, the seriousness of crime will obviously be a dictating factor in this. But I think for us it's about the ability to apply and for that to be reviewed, and those things again to be proportionate and necessary. But Rachel, I know you'll want to comment on that as well.
Funny enough, yes. So this is to do with the recommendations 21 from the Youth Justice Review, and that's stemming back to 2011, and then there's the Tracing and Review report in 2021. So just to be clear that this is not an automatic wipe slate clean at 18, that the recommendation is. And I'm when I read the EFM as well around this, I'm not too sure what the explanation doesn't really give us a lot of information for the position on it and the one that's been put forward. So there are no calls, to be clear, there are no calls from us that children and young people get away with things at 18 and it would never appear on a record for offending behaviour. This is about an application process. So we have something in train at the moment and in place, and as part of this part 4, it is legislating on the process that is currently in place with the independent reviewer, and that's the current rule. But it's the recommendations to have an application process to have a wipe slate clean rather than wait for an Access NI or criminal record check to be applied for. because that is whenever the consideration is whenever there's an application from, say, an employer or a potential employer, and that's when the decision would be made. What we're looking to see if we can get an application process. Somebody turns 18 and makes an application, perhaps the independent review, perhaps somewhere else, to have the information that is no longer relevant to be wiped. And we're not saying that everything would go, because obviously there would be safeguarding concerns with that, and depending on the seriousness of offence. But it's the application process rather than once you reach 18, everything goes.
Yeah, and I suppose, Rachel, I mean, it's a good answer, and I get the point you're making, and you've clarified it well, that this is a process we're talking about. I think we always sort of think about your patch and the young people, and we're talking about 10-year-olds and 12-year-olds and 13-year-olds, but actually we're talking about people up to the age of 17 years of age and up to and just before the age of 18. Yet the moment you take a day over the age of 18, that process is no longer open to you. So that's why I say, why the arbitrary age piece to this? Why would it not be more based around what a crime would be as opposed to what an age would be?
Well, if the committee would like to look at having an application process for everybody to wipe their slate clean, I'm sure that would be fine. But we're dealing with the current position, which is legislating on children, and that's what the Part 4 is, up to age of 18. So it's up to whenever you're an adult, and we don't think that it would be just on the seriousness of offences. You know, it would be on the seriousness of offences, but it wouldn't be. This would be not having your disposals at 11 years old, or your CRNs at 11 that are absolutely not relevant to anything anymore, for depending on the offence. This wouldn't contain things, even if it was committed at 17, on sexual offences, for example, or anything of the more serious offences. That wouldn't be part of the process to wipe clean, because that obviously comes with safeguarding concerns. These are for the minor offences that are already ruled out by the independent reviewer. You would just be able to apply to it, rather than waiting for a number of years to pass by for a criminal record check to be issued for your behalf. So, for example, to get in this position, I had to do an enhanced criminal record check via Access NI. That is when that process would kick in if I had any disposals at under 18. Should I have not at 18 been able to give the opportunity, as recommended by the Youth Justice Review and a number of other reports across the United Kingdom, on having that application process that I could apply and then have a clean slate going forward? It's just another way of looking at it, another avenue to get, not essentially wipe your slate clean, if appropriate. It's not a blanket policy.
Yeah, and I guess just delving into it, Rachel, I mean, really what we're doing is just try and tease it out so everybody understands that. I think it's important that people understand it, and particularly the public understand that. So the question would be, and they'll put this in the most extreme level possible, you know, that's what the people do. So if a 12-year-old is charged and found guilty of a sex offence at 12, would they be allowed to apply for that to be wiped clean at the age of 18? That would be the question that people will ask, because they'll go to the most extreme.
I think it could apply and it wouldn't be granted. That's not, just because an application is in doesn't mean that there's a granting. And it's the same as what I understand to be the current process. If there was an application into the independent reviewer and there was that kind of disposal on your record, that would obviously be shown. But we're talking about here is applications at 18, and we're talking about minor disposals, and those kind of minor disposals, it's my understanding, are not given for serious offences. So we're talking about low-level offences here. We're not talking about the serious ones.
I think that's key to focus on that we're talking about low-level stuff. I mean, you know, for people to understand it better, I think that needs to be really highlighted, you know, when we're talking about this issue. Again, thank you, Rachel, Chris, and Chair.
Thank you, Doug. Just to come back on, sorry, I think this just really does come into bring into attention actually the importance of information and accessible guidance and understanding of what this is. An extremely complex bill. This is an extremely complex area of law as well. We do need to really look at across all of this, not just from a children and young person's perspective and access to information, but for us all to be educated on the justice system, criminal justice, and what we're talking about here. Because most of us will not have a clue until something goes wrong. And that is, then we have to start Googling and searching online for information about what this all is. And I think this does just bring into the importance, we have put it into our submission about training, information and access and guidance, just for everybody, but obviously specifically for children and young people, and what goes on their records and the implications of all of this on their future, and what will happen, which we don't believe is in place at the moment.
No, you're absolutely right, Rachel, because I mean the justice system is probably one of the most confusing areas that's out there, and that's why I asked a question earlier on about, you know, how much do we focus on the victims here, because the victims won't get this, they won't understand this, because it's so complex, and that's why information and training is incredibly important. Listen, thank you.
Thanks. So, Danny, just before you come in, do you mind? I'm going to ask a question just on this specific
Yeah, go ahead,
point.
mind just.
Rachel, you'd indicated there are kind of low-level offences. To your mind, what are low-level offences? So I want to ask you a specific issue. Sometimes there are certain behaviours that are indicative of more serious criminal activity that's likely to follow. So, for example, cruelty to animals, cruelty to other small children, that can lead into, you know, those are indicators of, okay, this person's going to be a problem as they age and adulthood. Do you envisage offences like that as being wiped clean?
I would hope that if anybody was displaying those type of behaviours, that they would have a social welfare response and support in place, that there wouldn't be any behaviours like that being displayed that wouldn't be to the attention of relevant authorities and support systems. And that would be part of our calls for early intervention and prevention work, and family and parenting support throughout of all of this, and also support within the community and voluntary sector, and from a social welfare and child rights position. I don't see how you could, with respect to this bill and this as well, consider potential future behaviour. I understand your point, Chair, but I don't know how this would be relevant if the offences haven't been committed, and there would be a disposal on a record.
My issue, I suppose, is if a child is found guilty of offences around cruelty to animals or other children or whatever, the facts are that's often an indicator. So the offence is there, the child is found guilty. You're talking about low-level offences. My question to you is that a low-level offence that should be wiped? I mean, what's the level of offence is what I'm asking.
Yeah.
Because sometimes these things are indicative of likelihood for future offending and more serious offending. You know, so that's what's the level of offence that we say, okay, well, that's fine, we'll let that one go?
Well, I would say yes, that should be wiped. But I think Rachel's point around a social care response is absolutely crucial.
I think it is too, Chris, but the problem is it isn't there. And so, you know, and that's where some of this stuff becomes an issue, you know, in terms of the parallel processes. It's the same issue with the equal protection thing that we'll come on to. The problem here is all of those things should be moving in parallel so that, you know, the supports are there, but they're not. So while they're not there, we need to be mindful of the gaps and the unintended consequences.
Yeah, I could give you lots of examples of you know, young person, playground accident, is convicted, somebody's leg gets broke, young person convicted of assault. That goes on their record. That young person can't travel to America. That young person can't go to a certain university to do a certain course. You know, there's an example of, well, I suppose the question about criminalising that child in the first place, put that to one side. But there's an example of a wipe slate clean. Another young person using marijuana at the age of whatever, let's say 14, caught by the police, criminal conviction, involved in programmes, doing really well in life, gets job, you know, again, like life limiting opportunities, can't travel, can't do this. I would absolutely say wipe slate clean. Child in Derry, Londonderry, caught throwing a petrol bomb, criminal conviction, 10 years old. Let's ask who put that petrol bomb into that child's hand. Let's ask those questions, but absolutely wipe slate clean for that child, providing that, I suppose, the supports. Well, you would. I suppose I'll stop there because you've made the point about the supports not being there. But I think all of those scenarios point to why wipe slate clean is appropriate. I think it gets more complex with regards to the severity of the crime, and I think that's what Rachel is saying around the application process, and that you would have a suitably qualified person or people to make those calls.
I agree, and that's why I wanted to tease out the issue.
Yeah.
But I think these things are always black and white in terms of legislation.
Yeah.
So if there's going to be a sliding scale on this, we need to have an understanding as to what it is, because we're going to have to go in here and vote for it, one way or another.
Yeah.
Danny, you wanted in there. Ciara, you want in on this point, or just in general you want in? Because I've got Danny waiting. So.
Ciara's muted, is she?
You're muted, Ciara.
It's specifically to do with, obviously, this is kind of the vulnerability of the children that we're currently discussing, and the trauma that.
Well, then I'll come to that, because Danny's waiting and he's indulged me, but yours is not specifically on this point. So Danny, go ahead. Thank you.
Thank you, Chair. And to be fair, Rachel actually covered above a lot of our answers when we're talking about early intervention, and it was just the examples you were giving, Chris, like someone who's very keen on youth work as well. You see it's all down to early intervention, and which the stigmatisation of our young people, they're already heavily labelled, and we don't know the circumstances, what happens and goes on behind closed doors. And just as a wee quick example, bees, and we know it all the time, summer holidays, Christmas holidays, we see an increase around our communities, whether it's an interface or just within the community of antisocial behaviour and all that, and certain kids will get labelled. But poverty plays a massive part in that.
Yeah.
And if we continue to fail them and label them and fill them behind bars, sure, all you're doing is cost them more money down the long run. It's the early intervention that's key, and that's what we need to see within legislation going forward. So, sorry, I have more of a point than because you answered it.
We've all been, I did 10 minutes ago myself. Ciara.
No, it's more question now in talking about the vulnerability of our young people and the trauma that they may have faced. And likewise, the learning, I've been working with a lot of young people just with regards to learning disabilities, etc., and you can see the vulnerability of them. So I just want to go back, Chair, if you'd allow me, to live links. And I do have a bit of a concern in the use of live links, particularly with children. So I would like to maybe ask, what benefits do you see in the continuation and rollout of live links? Probably first of all, and secondly, what safeguards can be put in place? Because I'm up for face-to-face is far better than the live links. I just think particularly when you're dealing with vulnerable young people. So it's just your thoughts on that, and apologise for going back to live links, but it's because of the vulnerability of children that we're speaking about today.
Yeah, Ciara, another great question, and one that we've talked about at length internally. I suppose from a best interest perspective, you've got to ask yourself, is being in a courtroom or in the justice system generally, how child friendly is that? I think the word you used there was safeguards, because in our submission we've highlighted that yes, the face to face is an important part of the justice system, but also the success of the remote evidence centre that I don't know if you visited it in Belfast, but that's an example of how successful live links can work. My default goes back to the best interests. The vulnerability of that child, their individual and very specific needs, and ensuring that very specific safeguards are in place and that correct information is given to the child and their family around the use. Joanne, I'm not sure if you want to come in there from a legal perspective.
Yeah, just in terms of safeguards, I think it's important obviously to get the child's voice in the decision making around this, so what they feel is best, and do they want to give live evidence, but also the key, and I don't think there's ever a time when they shouldn't have the opportunity and understand their right to legal representation. It's really important in terms of access to justice that they have legal representation, but also, you know, their appropriate adult, a registered intermediary, and that it's established that they understand what they're consenting to. So I think it's really critical that those safeguards, if this proceeds, are clearly set out in the legislation.
Ciara, if I can just point you just to the bit we've talked about consent. So within the bill, it's Article 46ZA, and it's about the functions of a police officer under that article, and it has a list of criteria to meet, one of which is the appropriate consent and what that means. So for those who have attained the age of 18, consent is given by the person. For those who have not attained 18 but are attained 14, it's the consent of the person and the person's parent or guardian. And for those 14 and under, it's just the person's consent, or the parent's parent or guardian's consent, which we would question because that doesn't meet the standards of the voice of the child as outlined in the UNCRC. Would question about why there isn't any specific mention to the child's best interests and also vulnerabilities of children and young people, those with SEND or learning difficulties, anything like. There's no mention of that within those provisions, and certainly happy to point into specifics then that we would consider would be useful for the committee to look at, but we would question about who the appropriate adult would be in that, what that system looks like, but also ensuring that the voice of the child is front and centre and that they are able to understand proceedings, as there are bits and other bits of justice legislation about the ability to understand and attainment and age, because we don't just get to 14 and be able to consent or not consent, so it is very important to have the voice and experiences and the opinion of the child within the use of live links.
I think it was your paper that flagged up the whole issue of, okay, well, if one says yes and one says no, where are you left?
Right.
I mean, to be honest, I'm going to put it to the committee at the end of this. I mean, it would be my view that we should send your paper on to the department for comment, and I'll put that at the end. So I think those are things that we will pursue further.
Yeah.
Ciara, are you happy enough with that?
Yeah, thank you.
Okay, thank you very much. I'm going to move on because I'm conscious of time and that we have other witnesses waiting. Connie, on to general issues. I'm going to turn to you now on the criminal responsibility and equal protection issues.
Lovely. Thank you very much, everyone, for coming in today and presenting to us. I really appreciated your paper highlighting issues that weren't included in the bill, such as minimum age of criminal responsibility and equal protection. And I think I'd just like to hear a bit more, if it's okay, about your rationale for setting minimum age of criminal responsibility at 16. I absolutely agree, 10 is far too young. But the committee has heard from other attendees who've said 14 might be appropriate, and I would just like to hear a bit more about your rationale for 16.
Good question, Connie. And again, something we've discussed internally. The UN Committee on the Rights of the Child has recommended at least 14. Excuse me. The very short answer, and I will elaborate, but the very short answer is that I want this place to be the best place for a child to live. I want our laws and our policies to be child's rights compliant. I think that the age of 16, again, the age of 16 for me is an appropriate age. I suppose when you assess the maturity of a child, the whole rationale behind MACR is about the child's development, neurologically and otherwise. And again, back to the stigmatisation that Danny talks about. Rachel, I'm going to ask you again. I know you'll want to come in on this. But 16 as our age for MACR.
Yeah, and I appreciate there is much debate. I suppose from the outset it has to be raised 10 is far too young. The UN Committee have commended states that have 16. And there are a number of states that have 16, and also some have 18, like Luxembourg. So it is different depending on the states that you look at. But our position is 16 as the absolute minimum. and that is again based on extensive evidence of the harm that having a lower marker, minimum wage criminal responsibility marker. We talk in acronyms at Nikki, another acronym. But it's having a lower marker it's ineffective. It doesn't criminalising children at a young age doesn't actually make communities any safer. We know that. And the research, neuroscience, neurological research, all and just from a children's rights perspective, as we are, would have a 16 minimum wage criminal responsibility. And as Chris said, we would like this place to be the best place to be for a child and young person. So we would be looking for the best possible situation, and that is what the NCRC have recommended.
Yeah, that's really helpful, and I appreciate that you provided wording for an amendment as well, so thank you. I personally hope that's brought to the bill. Can I ask then on equal protection, just if you have had examples of any cases on how the current law is being used, and the negative impact it's having on children and young people?
Yeah, I suppose the current impact, you're talking about international evidence, you're talking about international best practice, and what we know now is the dangers to a child's well-being and the impact that can have on the child through their life and indeed into their adulthood. In terms of examples, I don't have any. I don't know if Joanne, you would?
Probably without going into specific cases, but maybe giving examples of things that would be concerning that could arise. There's certainly a confusion that can arise in terms of a lack of clarity, a blurring of lines, that can create difficulty, that can create a circumstance where proceedings, I suppose, the contact with children can be limited because of a parent's actions or misunderstanding of actions, without going into the detail of a particular case. But it's certainly something that we are concerned about. At the end of the day, adults don't have the right to assault each other, and why should adults have the right to assault a young person?
I think I largely agree with that. So thank you.
Can I, Johnny, you wanted on this?
Thank you. And it was actually a number of weeks ago when the Minister was in, confirmed that regional chastisement and raising the age of criminal responsibility would fall within the scope of the bill. So the first question would be, how much of a failure would this bill be if we didn't have these in them? And the second one would be, and I take the Minister's point around health having to be very much at the table around reasonable chastisement. Are you aware, have you done any engagement with health officials on as ground being laid, I suppose, within departments for this?
I suppose the first question on how much of a failure, I'm thinking back to Patricia Loosley's time as Commissioner, and she had worked really hard around equal protection, and that was some years ago. I don't have the maths, so it must be at least
There's one from 2008.
2008, yeah. So this is a long,
every mandate.
this is a long-standing issue. People in this room will have campaigned on it for many years. Indeed, Rachel, under a different hat, would have worked on it from the other side of the table. So I think it would be a failure. It would be hugely disappointing if it wasn't included in this bill. And I suppose that's on a positive note. This is a very complex bill. We're all trying to work out the complexity, but there are huge opportunities here. Yeah. There are huge opportunities to ensure that Northern Ireland is a more child rights compliant society, and this would put us, it would put us on par with other parts of the world. The second part of your question
was around engagement with health around reasonable chastisement, but as the Minister did highlight that would be a key component in this here that can't just fall with justice. If we don't have health at the table, it essentially won't work. It's really a remit of them as well.
Yeah, I don't know if colleagues want to come in, but Joanne did mention the Children's Services Cooperation Act, and I think with all of these issues, any committee we're in front of, you're looking across different departments, because these issues do straddle different departments and different ministers. But in terms of our engagement with health on this, well, I haven't had any direct engagement in this term with health. I don't know.
No, we were waiting for a family and parenting strategy. It's our understanding that might not be being progressed this mandate. We would actively encourage that to happen. we and others in this room and other organisations have issued a joint paper to yourselves as part of this call for evidence on equal protection. And there's two calls. It's reform of the legislation that must go hand in hand with family and parenting support. And that's absolutely fundamental. It's key to this. But in terms of not legislating on this and minimum age of criminal responsibility in this mandate, absolutely, it would be an absolute disgrace and missed opportunity. These are two fundamental breaches of children's rights that are currently being allowed for in our legislation in Northern Ireland, and it cannot continue. We've been talking about this for a very, very long time. There's overwhelming support of the majority of people in Northern Ireland to support the legislative change on equal protection and removal of the defence of reasonable chastisement. So we fail to see why there would be any delay, any further delay, because we've already had a number of delays on this, why this legislation wouldn't come into force.
Thank you.
Okay, Donnie. Well, I suppose to finish up, on some of these issues, like there's not executive agreement on the minimum age of criminal responsibility, and therefore I think given the nature and makeup of this committee, I suspect it's unlikely to be agreed here too, but I do anticipate there'll be an amendment. I think for us, the balance needs to be between, the support for families is key in this, because whilst we have no desire to see children be abused, we have no desire to see any form of punishment as a gateway for abuse either. We also don't want to see families and parents criminalised for a bad day. and that's the problem. If the supports aren't in place, you've got the criminal element moving ahead, but the support isn't there to prevent that. And I think that's where we need to make sure all of this ties in together. So I'm certain there'll be longer and more in-depth discussions around this issue.
If I would just encourage the committee to consider the other countries that the defence of reasonable chastisement has been removed and there hasn't been criminalisation of parents. That hasn't been seen in any of the places that have removed that defence. That's not to say that every single country and state that has that defence removed has serious and good robust parenting strategies in place. There's been, the NSPCC did a research in 2022 I believe, and the majority of people saying that they would like that defence removed, but also that they would like education and training and resources, but we should be having that in place for our parents and families anyway.
Yes.
So it's not just on this issue, this is just about looking at the child best interest, best start in life, and having those supports around the child in a family and a community. So you're saying that it takes a village to raise a child, it absolutely does, but we also need the resources and the support there from government. Again, not to say that that doesn't exist. There are lots there, but it doesn't. The countries that we have looked at on introducing equal protection has not increased in any way criminalisation of parents, and I think it would be something that committee could consider in that.
Well, I think that's my issue, that we are going to, these are conversations that will need to be ongoing, not just in this room, but actually in our parties, and people need to tease out the issues and how society has moved on and to look at it in the wider arena. So I'm not going to make promises to you today on that. I don't think any of us can. What I can say is I have no doubt that these discussions will continue in parties and in this room as we work our way through the bill. Whether there'll be agreement, I don't know. But certainly it remains in our consciousness,
If you'd like any further information, I'm sure there's a wealth of knowledge within this sector,
yes,
but we'd be more than happy to give any information, seek any information on your behalf with relation to this, but we do see this as one of the fundamental children's rights breaches in Northern Ireland that is going, and we would very much encourage the committee to look at this, or individual MLIs to legislate in this mandate, because it is a matter of urgency.
Well, as I've said, Rachel, we are going to look at it, but I can't go beyond that. There need to be discussions, and certainly I think a number of us want to look at the whole thing in the round, because it's broader than just a justice issue. With regard to equal protection, that was with regard to minimum age of criminal responsibility. Those two things are the same. We want, there will be more discussion, there will be more research. Again, look, there's not executive agreement, there will not be party agreement. So I suspect this is one of these ones where we're going to have to just tease it out further and see where we all land. and we may end up a bit closer than we did in the last mandate. I don't know, but we may not, and that's the nature of democracy. We'll debate it out, we'll consider the issues, and I think that's the great thing about this committee. It's a really engaged committee, and we're very eager to think about things properly and carefully and see how things might move on. So maybe the minds won't meet this time, I don't know. I'm not going to predict one way or another, but maybe it'll move forward another step, and that's always progress, I think. Right, spit and bite guards. The policing board debates this pretty much monthly, and the pros and cons of it. It's not that straightforward. I'm going to leave that in their arena for now. We've got quite enough to consider. So we'll no doubt come back to that. But look, thank you very much for your time today. I'm conscious that we've got others waiting. You've been very generous with your time and your information. Doubtless we will speak further, but thank you for taking the time today. It's been really informative and helpful. Thank you very much.
You're welcome. Thank you, Chair.
Thank you. Members, just as we discussed earlier, are members content that we would send the Nicky paper on to the department for comment because of the issues raised within it? Yeah. Members agree, Jess?
Agreed.
Yeah, thank you.
Great.
I just think it would be useful to get the department's perspective on some of the issues. I'm still not clear that we've got to the bottom of the numbers game, to be honest. So that's helpful. Right, agenda item 5 is still the Justice Bill, and it is the oral evidence from the Children's Law Centre. Could I ask members to turn to pages 3 to 74 of the table pack, and I would invite the members from the Children's Law Centre to come forward, please. Members, we have Paddy Kelly, who's the Director of the Children's Law Centre, Eamonn McNally, who's the Senior Solicitor, and Fergal McFerran, Policy and Public Affairs Manager, who are here with us now to give us some evidence. Folks, you're all very well. I'm fairly certain that what I have here is not what's in front of me now. Let me see who we've got. Oh no, it is Paddy. I'm sorry. I'm thinking.
You're very.
Apologies.
It's not a problem. It's not the first time that it's happened to me.
Presumption. I'm sorry about that, Paddy.
Totally understandable. I'm well used to it at this stage.
I was looking down at my page and saw names, and I was like, oh no. So apologies for that, and thank you very much for your forbearance as we kind of worked our way through the issues there with Nicky. But maybe in some respects it'll make life a bit easier for you.
I hope so.
Thank you very much for your attendance today. We very much appreciate it, and we value your paper too. I'm going to hand the meeting over to you for your opening remarks, and then, as ever, we'll take questions. Is that okay?
Yes, thank you very much,
That's
Chair.
Great, thank you.
Good afternoon, members, and thank you, Chair, for your welcome and introducing us. We're very grateful to the committee for providing us with the opportunity to make a submission and give evidence today in respect of the Justice Bill as introduced. As you may be aware, the Children's Law Centre is a children's legal charity which uses the law to vindicate children's rights through legal advice, representation and strategic litigation, policy and advocacy work, training, research and ensuring the voice of the child is heard and taken into account when making decisions about children's lives. We are pleased to be able to assist annually thousands of your constituents access critical services to ensure their children are able to enjoy their childhood and realise their full potential. I would like to begin by acknowledging that members will have received our written submission late, which may have mitigated against you having had time to consider it in detail. The reason for the delay was the complexity of the bill and our wish to provide you with proposed technical amendments, including detailed consideration on a clause-by-clause basis, and in some instances proposals for potential amendments for your consideration. If members have not had the opportunity to fully consider our submission, we're happy to assist the committee by meeting informally to discuss it following today's meeting or by providing further written information as necessary. As we were invited to give evidence in respect of Part 2 of the bill, the submission largely focuses on that part of the bill, and it will be Children's Law Centre's intention to make further submissions to the committee in respect of other parts of the bill in the coming weeks. In the interim, we have within our submission provided you with links to the Children's Law Centre's response to public consultations on the retention of DNA and fingerprints and the proposal to use live links for police detention. CLC's submission is based on evidence accumulated over 27 years of working on youth justice policy and legislation, including our intensive engagement in the developmental process that have brought us to many of the provisions contained in the bill. Our proposals are evidence-based, drawing on our casework, direct experience of children in the criminal justice system, good practice here and elsewhere, and binding domestic and international human rights standards. They are also reflective of current scientific and other research, including on brain development. We note many of the provisions within the bill reflect current practice and will put on a statutory footing the very many changes within the youth justice system that have evolved over 2 decades. They will also give effect on statute to at least some of the outstanding recommendations of the Youth Justice Review. While this is to be welcomed, it is regrettable that the intervening period, because children and families have not been provided with the support they required, children have been criminalised unnecessarily and are now living with criminal records, which is and will impact on their life chances. CLC believes that the time has now come and that this bill is an opportunity to provide the next generation of children and families with the additional necessary supports and protections to ensure children are kept out of the criminal justice system and afford those working in the criminal justice system legal certainty. In addition to the detailed proposed amendments to the specific clauses in Part 2 of the bill, we discuss in our submission, we are also suggesting the committee considers the inclusion of an overarching clause relating to the interpretation and implementation of the bill and an amendment in the language used in the bill. We would very much welcome the committee supporting a new clause to be included at the start of the bill to ensure consistency with provisions of the Justice Northern Ireland Act 2002 as amended by Section 98 of the Justice Act Northern Ireland 2015. The 2015 amendment incorporated the best interest principle into the aims of the youth justice system, alongside the need to have regard to the welfare of children with a view to furthering their social, personal and educational development. We are proposing that this clause should apply to all parts of the bill. The inclusion of this amendment would also reflect and reinforce other statutory duties, including under the Children's Services Cooperation Act. In addition, we would also welcome the committee supporting our proposal that in all instances where the term juvenile is used in the bill, that it be replaced with child. It is CLC's view that the term juvenile carries a stigma associated with delinquency and wrongdoing, and is more reflective of society's understanding and approach to youth justice in the last century, whereas the term child is humanising and reflective of the actual legal status of an under 18. Using the language of child is therefore consistent with the rehabilitative rather than punitive approach to youth justice that is the prevailing policy approach of the Department of Justice in 2025. Substituting child for juvenile justice throughout would also overcome any confusion that might arise from the interchangeable use of the two terms in the bill. We wish to give as much time as possible to members to ask any questions you might have arising out of our submission, but we would like to take a couple of minutes to commend to the committee proposed amendments not included in the bill as introduced, which we outline in our paper. CLC believe that the bill represents a legislative opportunity and that the time is well overdue to address two areas of law and policy where the evidence for change is overwhelming, namely raising the age of criminal responsibility, McGurk, and repealing the defence of reasonable chastisement. We are aware that these have already been raised with you previously by colleagues, including from Bernardo's, Baswa and by Nikki this afternoon. At 10, our current minimum age of criminal responsibility is not only one of the lowest in the world and is in breach of international human rights standards, it also does not reflect the reality of our child justice system. Colleagues in the child justice system have, in the absence of raising MACA, worked extremely hard to remove children from the formal criminal justice system. The majority of children who are in the JJC on any given day are 16 plus. Younger children are diverted, albeit within the system, but many still receive a criminal record which can haunt them for life, creating barriers to education, employment, rehabilitation and travel. Neuroscience research has demonstrated that children under 16 lack the cognitive maturity to fully understand legal proceedings, consequences of actions, and impulse control. Children who come into contact with the criminal justice system are often the most vulnerable of children. Over 34% of children in custody in Northern Ireland are care experienced. Additionally, children from socioeconomically disadvantaged backgrounds and those with mental health issues, learning disabilities or histories of abuse and neglect are disproportionately represented. Instead of criminalise these children, early intervention, support services and diversionary approaches out of the criminal justice system should be prioritised. If the aim is to rehabilitate and support children to change their behaviour, criminalised children doesn't work. Rather, it stigmatises and alienates children, leading to reoffending. DOJ data shows that reoffending rates for young people who receive a custodial sentence are 80% within a year, proving that punitive approaches are ineffective. DOJ's public consultation demonstrates broad consensus among your constituents that 10 is too young. This legislation provides the vehicle to introduce this long overdue statutory amendment. In 2006, an amendment was enacted which provided for the defence of reasonable chastisement would no longer be available to certain offences committed against children. While this was a welcome step, it is regrettable that the defence remained on the statute books in respect of common assault offences under Section 42 of the Offences Against the Person Act 1861. The consequence of the limited amendment is that our most vulnerable children do not enjoy the same protection from assault as you and I do. Not only is the current legal position in breach of the UNCRC, it exposes parents to legal uncertainty. It flies in the face of evidence that physical punishment increases aggression and antisocial behaviour and causes depression and anxiety in children, which may continue into their adult lives, and very worryingly runs the risk of escalation into physical abuse. NSPCC's research shows overwhelming public support for a statutory amendment to protect children from being physically punished by their parents and caregivers. 65% among the general public, rising to 71% among parents, carers and guardians. It is clear parents do not want to physically chastise their children, but rather want help to enable them to support their children to grow and thrive. The argument for retention of the defence in respect of lesser offences was the need to put in place support to assist parents who face challenges. CLC believes that 20 years is sufficient time for the necessary supports to have been put in place. The public wants to see a prohibition on the use of physical punishment, and the bill presents an excellent opportunity to ensure our most vulnerable citizens, our children, enjoy the same protections as you and I do. We are obviously very happy to try and answer any questions committee members might have, but given the focus of our written submission has been on Part 2 of the bill, we would in particular welcome engagement on the relevant clauses that relate to the presumption of bail without conditions, concerns re the inability of children to perfect bail, and how to protect against the inappropriate placement of children with complex needs in the JJC, as exemplified by the disturbing but sadly not unique case of Sophie Rogers, who was one of Eamonn's clients and whose heartbreaking story was covered in the media a few weeks ago. Just to assure committee members, we have contacted Sophie's mum in advance of the committee today, and she welcomed us speaking about Sophie's case in our engagement with you today to assist you in exploring how this legislation might stop what happened to Sophie happening to any other child. Thank you, Chair.
Thank you very much, Paddy. Danny.
Thank you, Chair. Paddy, thank you so much. That was very informative, and Paddy, just for me starting off, really, just it's sort of going back to the age of criminal responsibility, and it's your wealth of knowledge I would like to tap into here about the failures of the past, because just in the last presentation we're listening that there's a chance that this may not even be, we won't get this over the line, even an amendment, and the Minister has said there's scope within the bill. So it's just sort of from your view, what were the feelings of the past, and how much of a feeling would it be for once again not getting this over the line?
I suppose I started working on this issue 30 years ago, and that was whenever the committee, UN Committee on the Rights of the Child, first recommended, because it was the first examination of the UK government, the raising of the minimum age criminal responsibility. At that time, we had, I think it was 3 juvenile justice detention provisions. One on the Glen Road, I think it was called, actually can't remember now what it's called. It's gone now anyway. The other was Lisnevan in Malile, which was a grade C prison, and the other was predecessor of the JJC. So the population of children in the criminal justice system was significantly higher. So I think at that stage, and I am delving far into my memory here, Danny, but I think even in the JJC alone, you were talking circa 50 children. So that is the risk. Never mind the other two establishments, that is the risk that we face in terms of the criminalisation of children if we do not raise the minimum age of criminal responsibility. What has happened in the intervening period, and I have to commend colleagues in the youth justice system for the work that they have done in the absence of the minimum age criminal responsibility being raised. They have worked very hard, recognising the particular vulnerability of younger children, to remove them from detention and from the criminal justice system. And I want to record a very strong personal thanks to Tony Kavanagh, who used to work in the youth justice system, who has done a lot of work to get us to this particular place. But what actually happened at that stage was they closed down Lisnevan, they closed down St Pat's, in the Glen Road, that was the name of the institution. And Tony and his colleagues in the youth justice system worked very hard to remove those children, especially younger children, out of a detention in terms of the justice system. Until such time, and these were the assurances that were given to us then, as the minimum age criminal responsibility would actually be raised. So we are now at a stage that if you go down to the Youth Justice Centre at any particular day, the majority of children in there are 16 plus. The majority of them, I would say as well, are on bail, are on remand, awaiting bail and unable to perfect bail, and we will no doubt come on to that at a later stage. The majority of 16 plus probably, as I say, waiting to perfect bail. And are in for very minor offences. So what we would be saying is that by raising the minimum age criminal responsibility to 16, you will actually be reflecting what the reality is in terms of the youth justice system currently. And I mean, I suppose what I'm saying as well is that the world hasn't fallen apart by the fact that effectively, in all but statute, that cohort of children under 16 are not being detained in juvenile justice centre, and that those large numbers of children are being diverted, say, albeit within the criminal justice system, but being diverted as opposed to being criminalised. And I think we are now mature enough and developed enough in society and learning from the work of Tony Kavanagh and others. I think we are at a place where we can actually take that next step. Can I pick up on one question in terms of the actual age of 16? I think it was Connie's question. We have been discussing this with elected representatives since the Assembly first came up and was established. And at a particular time, I think it was 2008, that we were having very intense discussions, and we were very lucky to have the chair of the UN Committee on the Rights of the Child in Belfast for one of our annual lectures at that stage. And I spent a lot of time talking to her about what it is, given the committee had said, should be raised to at least 12, but progressively. And what she said to me was that why this committee had said 12 was because it was to give comfort to some countries where it was as low as 7 and 8 and who would not be well-developed democracies to actually move to 12. But the expectation of the Committee for Developed Democracies like Northern Ireland is that the age of criminal responsibility should be 16. And I think that's reflected in a reference we make in our submission, that she actually said that publicly in our lecture. So that's where 16 would come from, and it is reflective of the UN Committee's views in terms of developed democracies. I don't know whether that answers your question, Danny.
Well, it does. It's just, I suppose, as a new member to the committee, for me, just the chance of it not being a part of the bill, could be another massive failure, and it's an opportunity to undo probably the wrongs of the past 3 decades.
Yeah, and we will continue to criminalise our most vulnerable children, looked after children who shouldn't be in there at all, who were taken into the care of the state because of what has happened to them or because their parents weren't able to support them. So they are the most vulnerable. Our children with learning disabilities or mental health problems that Eamonn, goes down to the JJC to provide legal advice, etc. to, and we will continue to criminalise them. Yeah. And I don't think anyone in society wants that to happen.
Thank you, Chair.
Okay, Danny, thank you. Connie?
Yeah, thank you all for coming in today. I really appreciate your briefing paper, especially the insight you give us into bail specifically. And we obviously heard from Nikki about the inappropriate placements such as children who are on bail end up in the JJC. And you referenced Sophie Rogers, which is an absolutely horrendous case, and that is an absolute failure for that young person. And I wonder if you could talk a bit more to that and any experiences you have through the Children's Law Centre, and specifically any contact you have with the Department of Health around that, because it really does need a joined up approach with health and justice working together.
I'm actually going to hand over to Eamonn to answer that, because he's dealing with those children on a, if not daily, weekly basis.
Yeah, the case of Sophie is incredibly sad. The outcomes for her were horrible. You heard Nikki talk about Vicky. Vicky was I actually represented Vicky, instructed by the official solicitor at the time. So there's more than one Vicky. Sophie is another Vicky, and she spent a significant amount of time on multiple occasions in the Juvenile Justice Centre with bail, with the not being actually as a looked after child, not being put into the community in an appropriate placement by the Health Trust. Now, Juvenile Justice Centre have to be commended, because they really did step up to the mark and did their best with the situation that they were in, but she shouldn't have been there, is the key point. She had bail granted by a court, the bail subject to an address which was not provided by the Trust, which have a statutory obligation to do so. You'll see within our paper there that we provided you with a document called the Regional Good Practice Guidance. That document came back on the back of a case that the Children's Law Centre brought in 2012 called JR 66. And there's a very clear pathway in Appendix 11 set out for when a child is given bail, brought to the Juvenile Justice Centre, and what the responsibilities are and who is responsible for doing what and when. The issue that we encounter frequently is when we go up to the Juvenile Justice Centre, we meet with the young people, we do advice clinics. Really, it's not about their criminal case, it's to prepare them for coming back to the community so they can have the best opportunities of education, health, things like that. The majority of the young people we meet up there are sitting with bail. The majority of the young people are there for offences that will probably not attract a custodial sentence. The majority of young people have had their situation made aware to the Health Trust that they require accommodation or a bail address to be bailed. There's multiple cases on this, beginning right back with JR 66, there's MP's application, lots of cases. Judicial reviews have been in and out of the High Court on this matter, and it is very clear that there's an obligatory statutory obligation on health trusts to provide a bail address as soon as Article 21 of the Children Order is triggered, basically as soon as the child is given bail and has nowhere else to go. So we're sitting with young people in juvenile justice with complex needs that really require a health response. We've learning disability, mental health needs, autism, all sorts of things. And Sophie is a prime example of a young person with additional needs who requires additional support to be in the community, who required help, who spent long periods of time in the Juvenile Justice Centre, ultimately to have all charges removed on the basis that she wasn't fit to plead. So that's an example of Vicky 8 years ago, Sophie in recent years. You heard it in the radio a few weeks ago, I'm sure. So we haven't actually improved the situation for our young people when it comes to the bail. The courts grant the bail, but there's an opportunity within this bill to create a situation where the obligations are put on the health trusts to make it a reality. And in the earlier session you talked about the non-commencement of the provision around accommodation. That is really disappointing if that's not going to be commenced, because quite simply, if accommodation is the responsibility of a health and social care trust to provide and they don't provide it, and a court cannot grant bail without the accommodation, it will not come, because we don't have enough proper accommodations as it begins, as it is at the minute. We've had young people in the past placed in very inappropriate, unregulated accommodation, like B&Bs and hostel type accommodation, not so common anymore. But the situation is that unless it's included in the Act, then we won't get the accommodation, we won't get to that point where it improves.
Yeah, thank you.
Sorry, that was maybe a very long-winded answer to your question.
It's illuminating the scale of the problem, and I think it's extremely concerning, the impact and the implication for the rights of these children, that they're being put in such inappropriate placements and the impact of their well-being. Can I ask, how common is this? Because you mentioned cases 8 years ago, but it sounds like there's multiple children who are on bail in the JJC, and that it's totally inappropriate for them to be so.
There's a small number of young people in the JJC currently compared to years ago. So when we go up to the JJC, we go up every few months, we do advice clinics with them, but the JJC are regularly putting young people in contact with the centre because they know that we can try and help the young people to negotiate the path with the health trusts. Every couple of weeks we get a contact from a young person about this. Every time we go up to the Juvenile Justice Centre, there's 5 or 6 young people in, at least half of them are sitting with bail. High percentage of the looked after population sitting with bail. The system is just not doing what it should do.
I think that's extremely concerning. And can I ask what your interactions with the Department of Health and the Health and Social Care Trusts are around this, and what kind of feedback, or you've had no progress with them?
Well, as part of a programme of training, the SPPG of the Department of Health engaged Children's Law Centre last year to run out a series of training to all the health and social care trusts and to the housing executive on this area of what's called, what I term Article 21, which is really around homelessness generally, but a big part of that training is around the obligations to young people once they're granted bail, and when and how a trust should interact. And then there's a lot of discussion has to be had around the type and suitability of accommodation and supports, because we can take it back to, in the earlier session we talked about the impact of young people when they are granted bail on the victim. The fact is, when the young person is accommodated by the health trust, under the children order, 24 hours later they become a looked after child. So there should be a lot of health interventions going in around the young person, which doesn't really seem to happen in practice. So there should be a lot of help and support for that young person while they're on bail. The other thing that's important to remember is that when a young person is accommodated by the trust for that period of time, when they're on bail, after 13 weeks they become entitled to leave and aftercare. So there should be ongoing supports from the trust right the way through. And that's a key piece as well. So if they sit in juvenile justice, who, don't get me wrong, do a very good job with the young people, but they're picking up the slack for the health system.
Look, I have no doubt they're doing their absolute very best in impossible circumstances. That thank you for that, and thank you for your work on that, because I think that's something I hope we can maybe follow up, because that's really concerning. Thank you.
Chair, may I just add to that briefly?
Could you just give me 1 second, please? Can I ask everybody who's online to mute, please? Because we're getting some feedback and noises. Thank you. Apologies, Fergal, I just wanted to deal with that well.
Just to build on, because Eamonn's obviously reflected concern about the fact that aspects of the bill may not be commenced, particularly in this area around accommodation, and it's just to draw your attention to the recommendation we've made in our written submission in relation to Clause 8 to ensure that the language and the term solely that's specifically used is removed, because our concern is that where the implication of the aim of the clause is that actually the considerations of accommodation are not used to deny bail to a child, but actually the inclusion of the word solely could arguably, in some circumstances, allow it to continue to be the case that does happen. And so we've included a suggestion in our written submission that the term solely be removed, and think that would safeguard against some of what is happening.
Thank you, Fergal. Danny, you wanted to come in this point before we bring Ciara in?
Yeah, it was just actually asked this following Fergal, just the engagement maybe with the DOJ officials and the Minister around Clause 8 and maybe not being commenced. Have you had any?
We haven't had direct engagement with the Department on the bill itself.
No. How was it?
But we're happy for you to share our submission with the Department.
I suspect that's likely where we're headed. Ciara.
Just on this point, in relation, I'd like these just references to Tony. Tony, just in terms of kind of solutions to ensure children aren't remanded in custody unnecessarily. You had mentioned about the several pilots, such as bail fostering within certain trusts that have proven successful. Likewise, obviously, young people have obviously raised concerns too that it might bring additional stress. But could you throw some light on those pilots and how successful they are, and in which trusts they're working in? Thank you.
I think it was me you meant that for, yeah.
Is this to Eamonn, Ciara?
Oh yeah, Eamonn, is it? Yeah.
Yeah, thank you.
No problem. Well, the foster and bail pilot only ran in the Southern Trust, and it's only been for a very small number of children, so it probably hasn't really had the testing that it should have had. But take it back to its core. We have 5 health trusts who all face the problem of having to provide bail addresses for our young people. The appropriate accommodations don't exist really in the numbers that we need them to be in, and we've known this for well in excess of 20 years that we need to have the proper provision, and we don't have it. So while the foster and bail pilot was one idea of how to deal with it, it won't be right for every child. There are some young people, especially older children, who will have entered the justice system who will probably need supported, semi-supported accommodation, that type of situation, and it's just not there. That's what we're being told whenever we're interacting with the health trusts, trying to get them to fulfil their statutory responsibilities.
Just as a follow-up to that, has there been any other kind of, has yourselves or Justice thought of any other ways to address the accommodation needs? Because we're conscious of the trusts, and it's not just in relation to young people on bail, but in relation to other vulnerable people and adults with mental health problems and the issues with accommodation. So has there been any other discussions, cross-departmental discussions you're aware of?
There were some discussions at the time the review of regional facilities was talked about. It wasn't exactly a proposal that we thought would actually have worked, but there was thought of having a step down, essentially from the Juvenile Justice Centre, step down facility from the Juvenile Justice Centre that would allow for a bail address. We had some issues with that and how it was going to work, and there was a lot of detail lacking on it. But mostly what's happening here is it's back to you heard colleagues talk about the Children's Services Cooperation Act. There's not joined up working between the 5 trusts to solve this problem. Everybody's doing their own thing, and that doesn't lead to good outcomes. It also leads to situations then where in certain areas there's a lack of appropriate accommodation. And as I said, not so much in the now, but in the past, we have had young people in what are termed unregulated accommodations, but are B&Bs, hostel type accommodations, wholly unsuitable, away from any family that they've got, away from any school placement they've got, away from any CAM support they've got, just because it is the only thing that's available. So that's a situation we never want to be going back to. And in fact, we have always argued that the Supreme Court was very clear that hotels, hostels and B&Bs should never be used as accommodation for homeless 16 and 17-year-olds, even though it was predominantly very popular for years and something we argued against.
Ciara,
Thank you.
could I actually take it back a step further and go back to, if you look at the profile of the children and young people who are in the JJC and the overrepresentation of looked after children. And that is a result of an issue that I have been working on for 25 years, where there is a willingness, I think maybe that's a too strong a word, but there is the occurrence where staff in children's homes are more likely to call the police in situations where police would not be called if the child was living at home with their natural parents. As a result, the child is removed from the children's home and ends up in the JJC, sometimes because the children's home won't take the child back. And those are the children who are, some of whom are in need of bail addresses. So if we address a situation, which is a long-term problem and has been going on, and I've had assurances from the trusts, from the old health and social care boards, etc., in relation to addressing this issue, that there will not be a readiness to call the police into situations where a child kicks off in a children's home, maybe because they're traumatised or whatever, or breaks a window or whatever, and that they are dealt with within a care setting, within the children's home, within their home, rather than the police being called and them ending up in the JJC. That will remove a cohort as well who are in need of bail.
No, thank you for that, Paddy.
Okay, thank you, Keir. Does anybody have anything else? I just have a couple of things. Could I ask you, obviously concur about the hostel kind of B&B hotel situation where even those children are susceptible to predators. I mean, it's a dreadful circumstance. But in terms of the issue around bail, beyond suitable accommodation problems, there's already an existing presumption of bail. So are there any other factors for why those children are not being granted bail? So the ones with suitable accommodation doesn't come into it. What are the other factors?
Well, this is going to sound a bit cynical, and I don't mean it to be, but
No, Eamonn,
it's
just
the
you say
reality
what
on
you
the
need to
ground.
say, it's fine.
Once a Health and Social Care Trust provides accommodation for a child, under Article 25 of the Children Order, the child automatically becomes a looked after child. So your responsibilities become more than merely accommodation. After 13 weeks as a looked after child, you are entitled to the full evening and after care supports, which can last from 18 to 21, and in some cases up to 24. So there's a disincentive, shall we say, to take these children on. The other issue is because of the total lack of appropriate accommodation that's out there. I have had multiple conversations with unnamed trusts, shall we say, where I have been told that we can't take these kids on because we have nowhere to put them. You know, this is the sort of conversations we have. So things have had to go beyond just trying to negotiate. Things have had to go to pre-action letters. Things have had to go to judicial review because we can't get the situation sorted. And it's not the fault of staff working on the ground. They are doing their best to try and find accommodation and addresses for these young people. But if it isn't there, you can't find it, and that's the problem.
So that presumably deals with the vast majority of children who are not getting bail. Are there any other, so for the rest, what are the reasons?
Well, there are different, the situation that you have, there's not getting bail, and then there's bail not been perfected. Okay, so they're two different things. So most young people who are granted bail will go home for the most part, or go to a relative. It's whenever you get into the situation, if a young
So they're
person,
granted bail, but there's no, and that's only down to suitable accommodation.
it's usually down to a suitable address that can be agreed by the court and the PSNI. There might be a reason why the young person can't go to a particular area, but you're back again then, don't forget of the looked after population who are already looked after by a health trust, who have been essentially arrested for an offence that they have committed or allegedly committed whilst in the children's home, some of which we have experienced very minor offences which no parent would ever call the police for, right up to the higher range things where there's no choice but call the police.
So that in Vicky's case.
Vicky's case, but even there's other practical ones. I, for example, recall a case of a young man who let off a fire extinguisher and was charged with criminal damage. I'm aware of a young person who seen a document that they were really emotionally upset about, and it's something they didn't know. They burned the document and were charged with arson. You know, we are talking about some offences that no parent would ever call for. Now there are the other scale where there's no choice but bring the police into play, but there's that mix that we see, and a lot of it comes back to what Paddy talked about, the zero tolerance policy, and the interpretation of a zero tolerance policy by trust staff can lead to the criminalisation of young people. We have seen it on multiple occasions. Also the policy of, they call it abscond, but it's not absconding. It's a young person being late back to a children's home. The police are contacted. When any child is late back home, half an hour, 20 minutes, their parents don't phone the police. We're in that type of world.
So we bit of common sense might resolve some of the issues.
We've always advocated a common sense approach to the zero tolerance policy.
Do all the trusts have a zero tolerance policy?
Yes.
Okay.
And you'll see the figures are reflected in, it was a newspaper article Fergal was involved in, thousands upon thousands of times that the police have been called to children's homes over the last year, disproportionately so.
It might be helpful for us to have some of those statistics.
We
if
can
you would.
share some of that afterwards.
It would be helpful if you would, please, Fergal. Just finally from me, so this is a situation where a department has from what you're telling us, for 30 years failed in its statutory obligation. Will the trusts have for that length of time? What then? What are the sanctions? We're seeing what the consequences are, but how can these bodies, these government agencies, fail in their statutory obligations for this length of time? What are the pathways? So obviously this is the Justice Committee. We can't take on the Department of Health. That's for the Committee for Health. But
the ultimate result are costly judicial reviews having to be brought for young people who shouldn't be in juvenile justice, because that's the ultimate response that has to happen when a government body doesn't fulfil its statutory responsibilities. It's not something we ever take lightly, but solicitors in private practice are having to do these as well on behalf of their clients, and very often we are providing advice and information to solicitors in private practice to enable them to bring challenges on behalf of the clients they're representing in criminal matters. But that's a very costly way.
But presumably it's still not getting those children out, because if there's no suitable address, there's no suitable address, so a judicial review isn't going to resolve that.
Well,
but I suppose my issue is, how are they getting away with it for so long?
Very, very often the issuing of proceedings will produce an address, so to say. That wasn't there beforehand.
But for individual children.
Yeah.
I think that's why it's so important, Chair, that Clause 8 is commenced, because as long as there is that safety net, in a sense of the JJC available, this will continue to prevail in terms of the approach in the trust. So to ensure that that this can't happen, it's really critical that the issues around accommodation in the bill are addressed.
No, you've been very clear on that, as has Nikki, and so have others actually. So thank you very much. Does anybody have anything further? No, we're covered. Folks, could I thank you very much, and apologies once again that we ran late with this, but you'll appreciate, as I said, we are a very engaged committee, and these are subjects that we do want to take seriously. So thank you for your time.
Thank you, Chair, and as I said, we will submit in relation to the other parts of the bill in due course, and if there's anything you want to come back in terms of the detail of some of the clauses, we're very happy to assist in any way.
No, that's really perfect, and I suspect the conversations will be ongoing, so thank you very much, and thank you for your paper.
Thank you.
Thank you.
Thank you. Members, could I seek your views as to whether or not you wish to send on the CLC paper to the department? Yeah.
I think that would be useful.
Right, that's great. Thank you very much, everybody. Much appreciated. Right, so members are agreed to that. Then we'll send that paper on to the department for consideration and comment. Thank you very much, everybody. Agenda item 6 is Justice Bill written papers. Item 6.1 is the Department of Justice response regarding the Justice Bill biometrics provisions and proposed amendments. At our meeting on the 27th of February, we received a briefing from RAISE on the Department's proposed amendments to the biometrics provisions in the bill. Following that briefing, we agreed to ask the Department to provide information on a number of matters, including the rationale for the retention periods and the accountability of the proposed Biometrics Commissioner. And the committee also requested a response to a range of matters identified in the RAISE paper. If I could ask you to turn to page 73 to 88 of the meeting pack, you'll see the Department's response there. Let me just get it up. Are members content to note that response, or do you require any further information or clarification? Certainly on the issue of the time frames, I'm still not seeing the rationale there. What they've told us is the other areas that they considered, but they haven't explained why they landed on 75, 50, 25, 5 years, 3 years. No. So, do we want to try that one again? It seems to be like it's a recurring theme for people, for witnesses, and all of this stuff gets published. So I think it'd be important. Our members agreed that we would try that and see if we can actually boil them down to. Please tell me that's right.
I don't know what that noise is.
That we really could try and understand how they've arrived at the terms that they have.
No, that's fine.
Let's try again. Okay. Members, also just to highlight, last week the committee had requested a table outlining requests for information and responses received in respect to the bill so that we could track things. So this is being prepared by the committee team and that'll be provided at the earliest opportunity, but you'll appreciate that's not a small task. Okay, so just bear with us all for that one. Items 6.2, 6.3, 6.4 and 6.5 are responses to the committee's call for evidence. So those are pages 89 to 122 of the meeting pack for the relevant papers. Just to remind you that we issued correspondence directly to a number of stakeholders on the call for evidence, and many are going to respond via citizens-based submissions, but some can be made directly to the committee, and a few of these are those very ones. Item 6.2 is from the British Association of Social Workers in Northern Ireland, 6.3 is from the Law Society, 6.4 is from the Policing Board, and 6.5 is from the Probation Board. Oral evidence sessions have been scheduled with the Policing Board and the Probation Board in May, and a date for oral evidence from the Law Society is going to be arranged. Are you content to note those submissions in the interim?
Yep.
Thank you. Item 6.6 is the roundtable event which we discussed in closed session. I would ask you to turn to pages 123 to 128 of your meeting pack. So just a reminder of the background. On the 30th of January, we agreed to explore options for a roundtable event for community groups and grassroots organisations to provide their views on the Justice Bill, and we indicated a preference that the event should be held in a venue outside Belfast, but that was at that time. I suppose now with the additional information that we have and additional considerations we wish to give, are members content that we would take that item back, maybe do a bit more exploring and bring it back to a further meeting?
Yep.
Content? Thank you. Also, just a reminder on this, we had suggested attendees for the event should include representatives from PCSPs, family support hubs, neighbourhood renewal teams, rural partnerships and women's group. A list of those organisations can be found at page 126 to 128. Just if members would take a look at that, so that whenever we're coming to the next discussion on it, people are au fait with the issues. Agenda item 7 is enabling access to justice reform programme, taxation of legal aid remuneration for High Court bail applications, an update on the consultation proposals, and it's a written paper from the department. Could I ask you to turn to page 130 of your pack? You'll see that the department has provided an update on the consultation on the enabling access to justice reform programme and has advised that the proposals in relation to reform of remuneration for High Court bail applications are still in development and that the analysis of options is ongoing. They've said that they're going to provide us with an update prior to the consultation being issued. So while this paper is to provide an update on proposals for consultation, the department has responded to a number of issues that were raised by the Bar of Northern Ireland during its oral evidence session on the Justice Bill on the 6th of February. As previously agreed, bill-related papers are going to be published on the committee's web page. Are you content that we would publish this because it impacts some issues raised around the bill? I'll come to you in a second, Ciara. First of all, are we agreed that we do that? Okay, thank you. Ciara?
I'd just like to ask as well, has these responses from the department been forwarded to the Bar also just for follow-up? And then I just think, obviously, DRJ have been stating that they've had living and engagement with the Bar just regarding the taxation reform generally, despite numerous attempts. However, we ourselves obviously got a very different response whereby they addressed any questions we put to them. So I was just wondering if DRJ are, if they're not content with the engagement thus far, what steps they are taking to address this. Thank you.
Well, we can write to the department and ask. And our members agreed that we would forward the department's paper to the Bar for consideration. Yeah, I mean, it's going to be there and it's going to be published anyway. I've no desire to make a bad situation worse, to be honest. But we need a resolution to this. So we're content to publish the bill pages. We're going to write to the department. We're going to forward the paper to the Bar. But in the interim, are you content to note the paper? Do you have any further clarification or information that you want to receive? No? All good?
Nope.
Thank you. Agenda item 9 is court-ordered community sentences for children. It's a proposed consultation. It's a written paper from the department. Sorry.
Agenda item 8.
Oh, I missed one. Apologies. Agenda item 8 is the antisocial behaviour response to consultation and proposed way forward. Again, it's another written paper from the department, at page 134. You'll see, members, the department has provided an update on the responses to the public consultation on proposals to amend legislation to help tackle antisocial behaviour. The department has advised that policy development on this is ongoing and that it's going to keep the committee apprised of developments that arise. And they state that any proposed legislative change isn't going to occur until the next mandate.
I'm sorry, Chair, I can hardly hear you with that noise.
Just
Because I tried closing it earlier and I
Couldn't
couldn't
get it
work
done.
it. It's at the top, it's open, and I feel like it's got this in one ear and I can't hear you, so very sorry.
No, that's all right.
Sorry.
So just to reiterate, any proposed legislative change isn't going to happen until the next mandate. Are you content to note the written paper for now, or do you have any further information or clarification that you would want or seek? Content to note for Ciara?
It's just in relation to, obviously, is there any possibility we could get any further information at this point around the detail of the difference of opinion by the advisory group around the two antisocial behaviour orders? And one of them obviously is the legal threshold to be reached for the imposition of an ASB order, and also the minimum age for imposition of an order. So can we have see what the difference of opinion was? That would be useful, I think, at this stage. Thank you.
Are members content that we ask for that? Yeah, and I mean, this doesn't preclude us from taking anything further as they bring us, or asking for anything further as they bring us updates. But that'll do us as a starting point, I think. All right, because I'm conscious there's no point in us kind of launching into the whole thing about this immediately whenever it's not going to be taken forward to the next mandate anyway. But I think we should still keep our eye on it. Members agreed? Mm-hmm. All right, thank you. Agenda item 9, court-ordered community. Now it's community court-ordered community sentence for children. Again, another proposed consultation and another written paper at page 171. At our meeting, the committee considered a written paper from the department regarding the proposed consultation. The committee agreed to ask the department for information on engagement with relevant children's organisations and on how the proposed court-ordered community sentences will relate to or impact on the provisions in the bill. The department's response is included in the pack. Are you content to note that response? Yeah? Are you content to note the proposed consultation and consider further when the results are available? Members, I need something audible.
Yes.
Thank you.
Yes.
Agenda item 10 is correspondence. There's a correspondence memo and 9 items of correspondence at pages 223 to 296. I'm going to draw your attention to a number of items, and then I'm going to open the floor for members to have an opportunity to comment on any other items in which they have a particular interest. 10.6 is correspondence from, the Assembly's Public Engagement Manager at pages 241 of the meeting pack, and it's an invitation to the committee to participate this year's Balmoral show. This was raised to the chairperson's liaison group. Obviously, there are committees that naturally fall into the flow of the Balmoral show. For us, I think it's maybe slightly different. And they did indicate to us, to the chairpersons, that it's actually quite difficult to run a normal committee meeting at the show. So I don't know whether members are very eager to go to the Balmoral show. I would have some concerns around ability to get there, parking, timing, and our ability to get on with the work that we need to do, because obviously we've got a fairly, we're in the middle of a bill, but I'm open to members' views on it. Does anybody have a strong feeling, or are you content to just stay here and carry on as normal?
Yeah, look, it was a very kind invite, and I think many of us will be there in other capacities as well. It's obviously a really significant event, but I think maybe best to hold our meetings here.
Yes, I think it's more practical in terms of the issues that we're dealing with, and the Justice Committee. People will be there but for our work, I think we're probably better to carry on. So members contend that we do that?
Yep.
That's great, thank you. Item 10.7 is correspondence from Relatives for Justice at pages 243 to 244 of the pack. It's a request to provide evidence to the Committee on the Troubles Permanent Disablement Payment Scheme. Would members like to invite Relatives for Justice to provide evidence? The other option, just in the meantime, is, because this is a serious issue and I think we're all getting some feedback around this and around people being re-traumatised and so on. And I'm conscious that there are elements of this that tie in with TEO, but in terms of the processes, it rests with the Department of Justice. Initially, I think it would be useful to hear from the department in response to what the Relatives for Justice issues that they're raising. See what the department says, and then it might be worthwhile setting up a meeting. And I'd like to hear from other kind of representatives of victims too on that. But for now, are we content to just hear from the department in response? So I think it gives us a bit more of a holistic picture that we can start to ask questions on, if that'll be all right. Agreed?
Agreed, yeah.
Okay, thank you.
Can I just clarify, when you say here, do you mean written response or do you want to take oral evidence from the department?
I think a written response initially,
okay.
Kathy.
Yep, that's fine, thank you.
Yep, content with written. Thank you. Item 10.9 is correspondence from an individual at pages 246 to 264 of the pack and pages 76 to 81 of the pack, and that relates to previous correspondence from two individuals about judicial practice in family courts and domestic abuse. You'll be aware that we've already agreed to meet informally with the Lady Chief Justice and separately with the Minister of Justice to discuss family court matters, and that informal meeting with the Minister of Justice is going to take place on Monday at 3:30 in room 21, and you'll all already have received a direct invitation. So first of all, can I seek your agreement that we would send on that updated correspondence to the Minister, just so that she's coming with as much as we have on Monday?
Yep.
Also, just for reference, members, I've asked the team if they could just pull together the correspondence for us all before we head in to that briefing on Monday. But obviously be aware that you'll all have received separate items of correspondence as individual MLAs from different people, so refresh yourselves on that too, it'll be useful.
Do we have any progress on the meeting with the LCJ?
Yes, I'm going to come to it.
Brilliant.
Well done, you're psychic. Are there any other matters anybody wants to raise with the Minister on Monday? To be honest, I think we've got quite enough there in terms of the domestic abuse and family courts, and I don't want us to stray massively. I think if we've got other issues, we've got other opportunities. I'd like to keep this quite tight, but that's, I mean, if anybody wants to raise something, we'll put it out there and see what the committee says. Any views? Content to stick with what we have for now? Thank you. Yes, Connie, regarding the informal meeting with the Lady Chief Justice, she's advised she'd be available on Tuesday the 29th of April, along with Mr Justice McKinney and Her Honourable Judge McCormick. It's proposed that an informal lunch is going to be held in the private dining room from 1 to 2 that day. Are members content for that lunch to be arranged? Yes, thank you.
Yeah.
Are you content to note the other items of correspondence, or do you have any comments to make on anything else? Has anybody got anything? Doug?
Yeah, Chair, if I can, to 10.3, page 232, it's the assessment on transgender. Can you hear me okay? Sorry, yeah.
Yes.
I'm slightly concerned because this has opened more questions than answer, and I don't necessarily mean about transgender, but the fact is that they say that every prisoner goes through a risk assessment, but they do not take into account other prisoners. And yet recently, I think this week or the end of last week, we had a situation where a victim of sexual abuse as a child was served his lunch by the person who was his abuser in prison, which makes me think that this assessment that prisoners get when they go into prison isn't really working right across the board. And in some cases, they're doing an assessment on transgender people coming in, which isn't equal to others coming in. And I'm really concerned that they do not take into account other prisoners. Can we try and get a readout of how they do an assessment on somebody who's just coming in as a normal prisoner who may have had a background of sexual abuse, as it was in this particular case?
I think we should, Doug, absolutely. Our members agreed with that. I had a similar issue on this item of correspondence, Doug, because I feel like they're not answering the issue. This, no. For me, the issue is not about transgender prisoners. The issue is about self-identification. And the learning from England and Scotland should have been that convicted rapists and sex offenders self-identified as women to be placed in a women's prison. Now, the risk there is not to those self-identifying prisoners. It's to the rest of the prison population. So it's not about transgenderism. It's about predators who will exploit self-identification. And it seems to me that the department is not answering our questions on that. And those were very serious issues in England and Scotland. And I'm concerned that in terms of their risk assessment, they're not even considering the possibility that that could happen here. And I think that is a gross abdication of responsibility and duty of care. I don't believe that this correspondence answers the question that we raised.
No, and I think you're right, Chair, and I think it's a safeguarding issue that I'm trying to explore here, because if a prisoner coming in was sexually abused as a child, and they're not robust enough to make sure that the person who's feeding him his dinner isn't the person who abused him when he was a child, then is that going to be the case for the wider population? And particularly if you look at women's prisons in regards to that, transgender people are self-identifying going into women's prisons. So that's where my concern is a wider prison population. I just don't think the safeguards are there.
No, so there's a number of issues here. One is this issue about the issue that you raised, Doug, about sexual abuse and actually thoroughly checking the risks. The other issue is mine around, look, the learning from England and Scotland is not about transgenderism. It's about predators exploiting self-identification. And I think we need to understand, well, in Northern Ireland, in terms of what goes on with assessments for individual prisoners and the risks of others, why the risks to others are not being taken into account by those who may exploit. And also, are transgender prisoners, or those who purport, probably is more accurate description, those who purport to be transgender prisoners, is it purely through self-identification, or is there any kind of medical assessment also by means of a safeguard? I would like to understand that. And I would like to know then what is the policy on self-identification. So that's where I'm coming from in those. If we're going to write, I would like those to be included. Danny, you wanted to come in and comment?
Yeah, it's just a wee small point, because language is very important in all of this, and like all prisoners' health and well-being are paramount. And it's just, let's be a bit careful when we say normal people. Like, transgender people have rights, and they should be protected as well. And just be careful with the language. We're mixing a lot of those things together. There just doesn't always sound very nice towards a transgender community. That's just a wee point.
Well, what I'm trying to say is this is not about trans people. This is about people who are predators, who are who are using self-identification. So
that's important of case by case basis and way things.
Yes, but the issue with it is, I mean, we've actually seen this in other parts of the UK, and I mean, there's a substantial. I mean, I don't think any right-thinking person could consider that it is acceptable to put convicted rapists into a women's prison. Like, I just find it astonishing, and I want to make sure it doesn't happen here. Connie.
Yeah, thank you, Chair. I have to say, Doug, I haven't heard the details of that case. I mean, it sounds absolutely horrendous, and it would be seriously concerned. But I think the case you're talking about, though, it wasn't transgender people, which I think highlights that, you know, in prisons we have a lot of very vulnerable people, and I think I've totally no problem with writing to the department to see how we make sure that everyone is protected from abusers in a prison setting, and how the case by case basis of each prisoner's need and safeguarding is done, for further clarification on that. So I think that would be important. But I'll look up the case Doug's talking about, because that, I think, also shows that we have a mix of needs in prison and vulnerable people. And I think language as well is important, and to take this on board. So thank you.
Doug, your issue essentially is whether or not is the efficacy of the risk assessment and the processes.
Sorry, Chair. My issue is this, where they literally said in the correspondence that they don't expand the risk assessment to other members of the prison. Now they're referring to transgender, and what I'm referring is to everybody.
Yeah.
Where a young man can go in. His name's Mark Villa, and the reason I can say Mark Villa is because he's already waived his right for anonymity, who was sexually abused as a child, and it was his father who was in prison for a separate for that offence. Was the one who was serving him from the kitchen. But the point I'm making is, when they did the risk assessment on this individual, they didn't take into account the population that he was going to be put in amongst. If you transcribe that to the transgender issue, then the people where that transgender person is going to be placed into, say a women's prison, for example, they're not even talking to the women to find out if there's any issues there. So it's that wider issue that I'm trying to explore.
I think that's right. 'Cause I think it's fairly clear that there are elements of risk assessment for individuals. Our issue is beyond that, and whether or not even for individuals it's effective enough. Because clearly they didn't look at the wider circumstances for that prisoner. I mean, that's horrific. I can't. That's absolutely horrific. So are members content that we would write and seek clarity on some of these issues? Thank you. Does anybody have anything else in terms of the correspondence?
Can I raise one more, please, Chair?
Yes, Doug?
Chair, I'm just going to bang this drum that I've been banging for an awful long time, and it's item 10.5, where they talk about Department of Justice sickness, absenteeism statistics. And if you read it, it talks about the Northern Ireland Civil Service demonstrated commitment to support women in the workplace through various initiatives, and they talk about a menopause policy, which is all well and good, but the Northern Ireland Civil Service Staff Handbook does not support women who are in the Northern Ireland Prison Service who have been subjected to abuse continuously, sexual abuse continuously, who find themselves having to go on the sick, and then they're denied, who are denied then excusal of sick because it doesn't meet the policy of injury, disease, and assault. And in fact, that assault has to be a serious assault. It can't be a cumulative verbal assault. So I still have to say that I am not convinced that the Northern Ireland Civil Service Staff Handbook is good enough for our prison service. So I just had to raise that, Chair.
No, I think you're absolutely right. I mean, and this is obviously the issue that we raised with the Minister and the Permanent Secretary a couple of weeks ago, whereby if everybody in the prison service is saying it doesn't work for them, I'm not clear why the Department of Finance just says, well, it is what it is. I can't believe that they're not prepared to look into it. Now, the Minister and the Permanent Secretary had agreed to raise that with the Department of Finance, Doug, so we'll see where we are on that, but I absolutely concur with you.
That was the letter that went. We have asked for psychological at that time, so we have asked. And
yes.
We have also pointed out that they're going to talk to as well. So
the letter has been sent, Doug, so hopefully we should be getting a response on that at some stage soon. But no, absolutely right to keep putting this on the record, because maybe the more it's raised, maybe finally they'll decide that they can't keep washing their hands off it and they actually need to look at it. Does anybody have anything else in correspondence? Content to note everything? Yep, thank you. Agenda item 11 is the forward work programme, page 298 to 306. Can I ask your agreement that we proceed with the sessions in the draft programme subject to any changes that have been agreed to today? I don't think there has been anything agreed, but look, you appreciate yourself sometimes availability for folks changes, so we just need an element of flexibility. Is that all right? Thank you. Agenda item 12 is any other business. Does anybody have any other business? No. 13 is chairperson's business, of which there is none. agenda item 14 is date, time, place of next meeting, and that's going to be in here on the 3rd of April at 2 o'clock in room 30. See you next week. The meeting is adjourned.
Committee room 30. Sound. Committee room 30. Sound.